19th of April. Friday, the 19th of April. Thank you. The clerk will now proceed to read the orders of the day.
Leasehold and Freehold Reform Bill, as amended in the Public Bill Committee, to be considered.
Now, we will begin with new clause 26, with which it will be convenient to consider other new clauses, amendments and new schedules as listed on the selection paper. I call Minister Lee Rowley to move new clause 26.
Thank you, Madam Deputy Speaker, and I'd like to begin by thanking members from across the House for their valuable contributions to this legislation. It's good to see so many people so many honourable members who have been involved in this so far here today. And I know that many have been campaigning for changes for this legislation for years. I will not be able to name everyone, but with the leave of the House, I would like to pay tribute in particular to the important roles played by my right honourable friends, the members for Bromsgrove and Newark, my late right honourable friend, the former member for Old Bexley and Sidcup, and my honourable friend from Redditch, who have laid the ground for many of the measures in this bill in front of us today. They have all been invaluable in helping us to get to where we are, delivering on the commitment we made to reform a system which clearly needs change and giving millions the freedom and security, the control over their own lives that comes with home ownership in its truest, fullest sense. Madam Deputy Speaker, at a stroke, this bill will provide that greater control for young people and many others and help to reduce unnecessary stress, uncertainty and time wasted by reforming a labyrinthine system and making it better. Buying a home, especially a first home, must be a moment of pride and celebration, a just reward for years of hard work, careful saving, sacrifices made, and for doing the right thing. Instead, for some, the dream of home ownership is not that. Instead, soaring service charges, rip-off insurance commissions, escalating ground rents. Overall, and most infuriatingly, a sense of being left in the dark and the system working against you rather than for you. This is bad for everybody, but it is notable that first-time buyers make up nearly half of leaseholders, with 15% of owner-occupiers aged under 35. They are the future of our property-owning democracy and rightly expect and deserve to put down roots and have the same stake in society as previous generations. And I'll happily give away my old friend from Whittam.
I'm grateful to the Minister. And it is specifically on this point that I would really welcome his views. He is absolutely right. And I've met with so many first-time buyers in my constituency who are now trapped. They're absolutely trapped because they're stuck in this cycle of increasing service charges, but even worse, facilities companies that are not actually maintaining their properties, where they've got serious issues and serious problems. We've got companies ranging from First Point, and I'm meeting with them at the weekend, but there are so many others. They've been raised in this house. Many of us talk about this. We're deeply concerned because our constituents have sacrificed so much. They've put all their investments and savings into this property, and clearly they have no accountability or transparency on this. We hope that this will absolutely change.
My right honourable friend is absolutely right, and the support that came from the benches more broadly when my right honourable made the points absolutely demonstrates why all of us are seeing many of these issues in our constituencies, and whilst it is absolutely vital, as my right honourable friend indicates, that we give people who have made the sacrifices to be able to achieve a first home the right and the greatest control over that.
Will the Minister give way?
Happily give way to my honourable friend from Walsall.
Well, I thank the Minister for giving way, because I have a case in my own constituency. Harvest Grove Victoria Avenue is the company that seems to be extorting money from leaseholders and not providing any of the works that it says it is providing, and then taking them to court and charging them for the benefit of having letters sent to them with invoices. And it feels to me that we, through this bill, desperately need to redress the balance between freeholders and leaseholders. Will the Minister see that that is the case?
My honourable friend is absolutely right. He makes a very important point about transparency, which is at the heart of the service charge changes which we are bringing into this bill. He makes an extremely important point about fairness and ensuring that if these companies have been not all companies will be doing things that are incorrect, but where they have been found to be incorrect, it is important that they shoulder their own costs. And that is why I'll happily take one more intervention at the stage from...
I thank the Minister. I thank the Minister for his generosity. It is not only companies which are exploiting leaseholders. The charity, St. Mary Magdalene and Holy Jesus Charity in my constituency refuses to allow the leaseholders to extend their lease or buy their freehold. Now, the charitable exception is very complex, and nobody wants historic houses to find themselves sold. But these are ordinary terraced houses, and the charity did used to sell the freehold and indeed extend leaseholds in the past. Is it possible for him to meet with me or my constituents to look at the ways in which in the future this particular issue can be addressed?
Thank you. I'm grateful to the Honourable Lady for outlining this. I know it's something that she's raised in this place before. As the Honourable Lady indicates, this is a complex area of law, but I would be happy to talk with her separately on that matter in the coming weeks ahead, if that's helpful. So how are we doing this? Well, we're doing it by giving leaseholders more security over the future of their home, by increasing the standard lease extension term to 990 years, by making it cheaper and easier for leaseholders to buy their freehold, by tackling unfair charges, exploitative practices and poor management, and in doing so, overturning centuries of iniquity. Madam Deputy Speaker, I'll give way to the Honourable Gentleman in one moment. Madam Deputy Speaker, this bill will also give leaseholders control. The control they deserve over the buildings they live in. At present, management companies are too often unaccountable to those who pay for them, meaning that they are able to charge excessive fees for poor quality service. The bill gives more leaseholders the opportunity to manage the buildings themselves so that works gets done properly and they have more of a say. I'll give way to the Honourable Gentleman from Sheffield.
You might anticipate the question I'm going to ask because I've asked it before. It's fine giving leaseholders easier ways to actually buy their freehold until you come across companies like Coppan Estates, who we've debated before, who just don't reply to letters. I think we're now on our third recorded delivery letter to them about the residents on the Flockton estate who've been just sent enhanced bills for their ground rent charges, no justification, but threats if they don't comply. Where in this bill is there any measure to make sure that Coppan Estates and their like respond properly in future, or there are consequences if they don't?
I'm grateful to the Honourable Gentleman. As he knows, we have extensively debated the iniquities of Coppan Estates, and I repeat that Coppan Estates are treating my constituents in a way which is inappropriate in the same way that they're treating the Honourable Gentleman's over the border. But coming back to my role from the portfolio perspective, by extending the opportunity for where there are charges to go to tribunal, I hope that the Honourable Gentleman's constituents in Flockton would be able to look at that, to be able to go to tribunal and be able to hold that company or other companies to account, should that be helpful. If I may, I'll make a little progress, and I will happily give way to the Honourable Gentleman from Brent North. Through these reforms, we will also scrap the presumption that leaseholders must pay their freeholders legal costs, even when they win at tribunal, correcting another historic and unfair imbalance. You wouldn't be expected to pay legal costs if you were successful in your claim for other cases, so leaseholders shouldn't be treated any differently. I'll give way to the Honourable Gentleman from Brent North.
Very grateful to the Minister, and can I say he's been most accommodating throughout the whole proceedings of the committee, and I think we're all grateful to him for the way in which he's listened. It's further to the point raised by my honourable friend, because he will know that there are many developers who now have located themselves extrajudicially in places like the Cayman Islands, Wembley Central limited apartments in my own constituency have finally ended up there, and there's many others. What in this bill is going to enable us to actually extend our reach and force these companies to respond, reply, and do what the law already says in the Building Safety Act that they ought to do?
The Honourable Gentleman makes an important point, and one that I know we debated at the committee stage, and he highlights correctly the challenges in certain areas of of how there is enforcement. If I may come back to that later in the debate. I'll give away one final time to the Honourable Lady from Walthamstow.
This way, and I do want to join with my colleague in saying, I recognise actually this isn't a partisan point because so many of us see the problems. He mentioned there about not paying the costs when you win, but many people will be shocked to discover that in a leasehold tribunal you set no precedent. So we can see companies time and time again exploit our constituents and it causes no precedent on which the courts and the tribunal courts could draw. Will he look at my Amendment 1, which seeks to set that precedent and give people the protection that when you know you've got a freehold manager who's mistreated people, they won't be able to do it with impunity because the courts will be able to take that into consideration if a tribunal has found so?
I'm grateful to the Honourable Lady, and I know that she feels strongly on this matter. The Honourable Lady, as she indicates, has raised this previously. The advice I have received, I'm always happy to talk outside of this chamber, but the advice I've received is that at the higher tier of the tribunal, there is the ability to give an indication of the direction of travel, and a precedent-like can be set there. But as I say, I'm happy to talk to the Honourable Lady separately. I will make a little progress, if I may, Madam Deputy Speaker. During committee stage, we made efforts to further improve and expand this bill. We moved 119 amendments, which included expanding leaseholder rights of redress, providing new guarantees that leaseholders will receive sales information, and tabled a number of technical amendments to improve it. And today, we are proposing further improvements, and I will now turn to the government amendments at report stage. And to start, I beg to move new clauses 30, 31, 32, 33, 34, 35, and amendments 23 and 49. Building on the legislation brought forward by the Building Safety Act 2022, the government has tabled a number of amendments to clarify and extend protections in some specific areas. This will further prevent freeholders and developers from escaping their liabilities to fund building remediation work. The Building Safety Act provided leaseholders with a range of protections to ensure that those responsible for building safety defects were made to carry out the works or to pay for them to be carried out. However, before and during the process of remediation, relevant steps may be required to keep the building and the residents safe. Relevant steps include such measures as providing waking watchers or additional measures such as fire sprinklers or simultaneous alarms. Unfortunately, there have been cases where the landlord has failed to put these in place or failed to pay for these relevant steps. This has caused the leaseholder to bear the financial burden or the necessity of the local authority for stepping. New Clause 30 places beyond doubt that the first-tier tribunal can order the costs of the relevant steps are met when making a remediation contribution order or a remediation order. New Clause 31, it is often the case that doing surveys or investigative works to discover the full extent of remediation required on a building takes time, money and effort, and those assessments can be invasive. New Clause 31 will place beyond doubt that the first-tier tribunal has the power to order that a respondent must arrange and pay for evaluation surveys or experts' reports to establish the full extent of a building's defects. Turning to New Clause 32, we know that landlords of buildings 11 metres and above are failing to provide, in some instances, alternative accommodation for leaseholders when they are decanted from their homes. This amendment will place beyond doubt that in addition to relevant steps and expert reports, the costs of alternative accommodation for leaseholders and other residents when they are decanted from their homes can be recovered through remediation contribution orders. Turning to New Clause 33, resident management companies and right to manage companies allow leaseholders to have more control over their buildings. However, at the current time, these management companies are unable to fund litigation against non-compliant landlords, as they are unable to recover the costs for doing so from leaseholders in their buildings. This amendment will allow such management companies, where the relevant lease allows, to raise funds for remediation contribution orders, making sure we continue to hold those responsible for life-threatening defects to account. Turning to New Clause 34, this repeals Section 125 of the Act. This was intended to allow for the recovery of remediation costs relating to residential buildings of 11 metres and above in an insolvency, and for these funds to be used to remediate the building. However, there is a conflict with insolvency law, and there is a risk that instead of being used for remediation, any sums recovered under this clause could be directed instead to pay down the debt. This problem cannot be easily remedied, so we are seeking to repeal the section at this time. New Clause 35 Regulators need to be made aware if those responsible for relevant buildings, that is, responsible persons, become insolvent. This clause introduces a duty on insolvency practitioners to notify local fire and rescue authorities, local authorities, and where necessary, the building safety regulator. I now also beg to move new clauses 42 to 66, new schedules 2 and 3 and Amendment 84. We know there is little justification for selling houses on a leasehold basis. For years, developers have exploited the sales of houses on a leasehold basis for the sole purpose of generating an income stream from ground rents and fees. This has come at the expense of consumers who receive little to no benefit in return. We promised to shut down this abusive practice by banning the sale of houses on a leasehold basis, and today we are doing so. Other than in narrow services, I will in one moment, to my right honourable friend, other than in narrow circumstances where a lease can still be justified, all new houses will need to be sold on a freehold basis. And I give way to my honourable friend, Aldridge-Brownhills.
Thank you, Madam Deputy Speaker. I'm really grateful for the news from the Minister from the dispatch box, and that goes a long way, certainly, to addressing the amendment that I put down, which is new clause 13, but he specifically makes a point about banning the leasehold sales on new houses. What consideration will he give, though, to extending that in the future to banning leasehold flats? Because I know that's of a concern to a number of us, I think, across both sides of the House.
I'm grateful to my honourable friend. I know she's campaigned extensively for the ban on leasehold houses, as I know many in this chamber have, and I know she's spoken up in this place before on this, and I'm grateful for her support for it. She also rightly raises the point about ensuring and the extensive debate which goes on in terms of the potential extension into flats. The government remains committed, and the Secretary of State, the right honourable member for Surrey Heath, has said on numerous occasions at this dispatch box that we remain keen to make progress on finding an alternative workable solution to leasehold flats, which most people in this place recognise is probably common hold, and there will continue to be work done on that, and we hope to be able to make further progress on that in the future. Common hold has clearly started a significant amount of interest. I'll give on way first to my honourable friend from...
I thank my honourable friend for giving way, and indeed for what he's saying. Clearly there are certain building companies in this country, Bellway Estates, Bellway, for example, Bellway Homes, sorry, get it right, whose policy it is to literally sell the leasehold to leaseholders and then sell the freehold to a company that then exploits every aspect of the freehold without even informing the leaseholder that they've done this. Surely we can close this loophole. We could close it this afternoon by ensuring that the freeholder must give the leaseholder first right of refusal to purchase the freehold.
I'm grateful to my honourable friend, and he raises an important point. I know this is an amendment which has been put down by the honourable gentleman for Sheffield South East. I will come to it later in the debate, if I may. I'll give way to the honourable gentleman from...
Out to the point of the honourable member for Harrow West and Bellway East. Sorry. The Bellway are certainly a company that have done this, and indeed many people did not even realise that they had a leasehold house, only to find out quite a while afterwards with all the costs that actually come down the road. And I welcome what the government have done, but it's really trying to find a good solution for everybody that is now finds himself in this position. And these houses in years to come may well become very difficult to sell.
The honourable gentleman makes an important point about how we need to make sure that this regime works, and we recognise that there are challenges within it, which is why we're bringing forward a number of the different measures. And my honourable friend from North East Bedfordshire.
I'm very grateful for the Minister giving way. Just on this point of existing contracts that have been signed by people purchasing a leasehold property, is it the view of the government that those were legitimate contracts, and therefore there is a risk about trying retrospectively to reverse the conditions of those contracts? Or is it the government's view that those were abusive contracts and therefore there is a public policy interest in retrospectively eliminating the leasehold element of them?
I hope I'll be able to answer my honourable friend's questions in a moment when I just run through quickly the amendments which we are putting down. But whilst we recognise we are banning the sale of leasehold houses in all but unusual circumstances, but for those where they're out there at the moment, there is obviously the ability to ensure that to buy the freehold and to move from the leasehold challenges, which many honourable members in this place have highlighted, to move to freehold. But let me come to some specifics, which I hope will answer some of the points which have been raised. New Clause 42 bans the grants of new long leases of houses. It will cover both newly built houses and existing freehold houses where the owner attempts to grant a new long lease. This new clause also closes a potential loophole by preventing the later sale of a lease where circumstances have changed between the date the lease is granted and the date the lease is assigned. For example, this thwarts a developer from granting a lease of vacant land to a sister company, building a house on the land, and then selling what is now a leasehold house. New Clause 43 sets out the broad conditions of what properties will be captured in the ban. Each of these broad conditions are then defined in the subsequent 4 clauses. New Clauses 44 and 45 specifies what constitutes a long leasehold interest for the ban. It adopts the established definitions in law, which are familiar to developers and homeowners alike. New Clause 46 sets in definition in law a definition of a house for the purpose of this legislation. This is a broad definition which should reflect what prospective buyers would rightly consider to be a house. The definition will also capture attempts to create minor interdependencies between 2 properties which developers might create in order to try to get around the ban. New Clause 47 confirms what is a residential lease. It provides that a long lease of a property will be a residential lease if the lease does not prevent use as a separate dwelling. Again, this is a broad definition designed to prevent mis-selling of leasehold houses, but capturing only leases of properties used as a house. We recognise that in a limited number of cases, the use of leases can still be justified, which for the purpose of this bill we are calling permitted leases. We have consulted widely on what should and should not be exempt from the ban, and even the question of what is or is not a house for the purpose of this ban. The result is the collection of definitions now detailed in this bill in New Schedule 2. These exemptions will allow vendors to continue to sell long leases of houses where the use of a lease can be justified. This includes land where properties cannot be sold on a freehold basis, such as inalienable National Trust land, or where the product relies on a lease connected to an active third party, such as shared ownership houses or community land trusts. We are able to, and we will, if needs be, revisit these definitions and exemptions if innovation in the housing market requires it, or we see evidence of poor behaviour. New Clause 49 seeks to create an additional layer of protection for consumers and clarify which leases are permitted, usually where, for example, a developer is intending to sell a number of new leases of houses on the same site. Those intending to grant or sell leases that fall under one of the categories set out in Part 1 of the schedule will be required to make an application to the appropriate tribunal for determination on whether a proposed lease is permitted. This includes houses sold on land leased before the government announced its intention to ban leasehold houses in December 2017, and leases such as retirement housing leases or leases on inalienable National Trust land. To further add clarity for consumers and subsequent buyers, the tribunal will grant a certificate confirming that the lease is permitted and under which category. Critically, this must happen before the lease is marketed, so that potential buyers, to the point that the Honourable Gentleman from Helen and Deeside was making, can proceed with the purchase with confidence, knowing that the house is exempt from the ban. Not many developments will need to go through this process, but those operating where it isn't always clear if a lease is permitted or required will. And to make sure that consumers have access to the material information they need, and to ensure they have the confidence to make a decision when purchasing a new house, New Clause 50 requires those proposing to sell a new lease of a house to make this clear when marketing the property. To make sure that vendors comply with the new marketing requirements, this amendment relies on New Clause 59 to implement a new penalty regime. This includes a fine for failing to provide the required marketing information at the right time. And we know that not all homeowners will read, or home buyers will read the detail of all the marketing information, and that not all leases will be advertised. So New Clause 51 introduces warning notices so that all vendors will have to alert purchasers in writing that they are entering into a lease of a house or an agreement for the lease of a house, and on what grounds that lease is permitted. I will give way once more to the Honourable Gentleman.
Thank you again for giving way. And one of the problems was that many of these companies encouraged buyers to use their own lawyers, who didn't, shall we say, point out some of the pitfalls that leasehold properties have.
The Honourable Gentleman is absolutely right, and it's why I hope that amendments to new clauses 51 and the like help to go some way to making sure it is absolutely crystal clear in future that there is no way for this to be gotten around, and that there is clarity for those who are seeking to take that step into buying a new property. I'll just make a little more progress and I'll give way to Honourable Gentleman. New clause 52 will require all new leases to include a statement on the front of a lease that declares the lease is a permitted lease, or they are not registering a long residential lease of a house. Should the developer make a dishonest declaration to His Majesty's Land Registry, the homeowner may be able to exercise the redress right contained in new clause 54, which allows them to acquire the freehold from the developer free of charge. Under new clause 53, if the lease does not include the prescribed statements, His Majesty's Land Registry will have the power to restrict the resale of the property until the right information and declarations have been made. I'll give way to the Honourable Gentleman from Sheffield.
He's talking now about the information on purchasing houses. Is that going to apply to flats as well? But for anyone buys a property, it has to be explained to them they are buying a lease on a property and what that entails. I've actually got a new clause 38 down, which says that everyone buying a lease should be presented with a copy of the government's how to lease document. So there's independent advice there, which should be given to everyone in this situation.
The discussion I'm focusing on at the moment is homes, because we've been so emphatic and so clear that they are precluded in exceptional circumstances. I'm very happy to talk to the Honourable Gentleman both later in the debate and outside of this place about whether there are further consumer protections which may be proportionate and reasonable to those who are purchasing a flat in the future. New clause 54 grants homeowners who have been missold a new lease of a house the right to acquire the freehold from the landlord for zero cost, as well as any superior leasehold interest in the property. New clauses 55 and 56 set out that there are both protections and reasonable limitations to this requirement. And new clause 57 provides for the Secretary of State to make regulations which will set out further details on how redress can be obtained. We understand, I will make a little further progress if I may. We understand that granting homeowners the right to redress alone may not be enough to prevent bad actors from attempting to breach the ban on the selling of a lease of a house, and that is why we are introducing a system of financial penalties where there is a breach. These will start at £500 for a minor breach, rising to £30,000 for the most serious breaches. And to enforce this system of fines, as we set out in new clause 58, we are asking all local weights and measures authorities to play a part where they see infractions in their area. And we will also set out how they need to work through new clause 60. The chief responsibility for investigating and taking action will be the responsibility of the lead enforcement authority. Through new clause 61, the Secretary of State will have the power to appoint the right authority to fulfil this important role, whilst new clause 62 details the duties. These measures, specifically in new clauses 63 and 64, also vest the appropriate investigatory and enforcement powers essential for both the lead and the local authorities to carry out the job by amending the Consumer Rights Act 2015. I'll give way to the Honourable Gentleman.
Thank you, Madam Deputy Speaker, and I thank the Minister for giving way. I wonder if he could assist me with an issue in my constituency which may be relatively unusual, and I have listened really carefully to the points he's made, and they're very helpful. In a development called Loddon Park on the edge of Woodley in my constituency, residents were sold properties where they then discovered, rather like my honourable friend from North Wales mentioned earlier, in the small print of the contracts, they then discovered that they were expected to pay a standing charge to upkeep open space on the development, even though they were freeholders of their own houses in this large development. And I wonder if he could look into this matter and write to me about what redress might be open to them.
Minister?
I'd be very happy to write to the Honourable Gentleman about the specifics if that is helpful. In addition to the building safety measures and the ban on new leasehold houses, the Government has also tabled a number of other consequential Government amendments to refine and improve the clauses already moved by this House, and I beg to move these amendments in addition. Now, with the leave of Madam Deputy Speaker, I would like to mention three key issues that were brought to our attention in committee. There are many, but three that I want to talk about today. I understand these will be subject to further debate today, but if I may, I want to acknowledge these issues. They are capping existing ground rents, which has already been raised, leaseholder forfeiture, which I know will be raised, and support for residents of freehold estates, which has already been extensively referred to. I know members will have questions about the Government's plan to address ground rents. We have consulted as the House knows, on introducing a cap on these through the bill, a consultation which we extended on request, and we are still at this stage as a result of that considering our next steps. We will say more shortly. I will give way to the Honourable Lady, to my right, my friend.
Thank you. I'm very grateful. I know the Honourable Gentleman has been very generous with giving way to interventors. But could he give us an indication of the timescale for this? I think it's something that many of us in this House would be interested to know. And does he anticipate he may be able to introduce something during the passage of this bill when it reaches the other place?
I'm grateful to my right honourable friend. Whilst I can't give the specific assurances that my right honourable friend is seeking at the moment, but we are trying to work through this at speed. We recognise it as an important issue. We recognise that it is vital in terms of the discussion that we are having today. But I know that honourable members and right honourable members in this place will recognise that this is a hugely contested area where there has been significant discussion already and people have very different views, and so we want to make sure that whilst we are moving at speed, we are taking our time, that when we do come to a decision and a conclusion, that is done in the right method and the right process. And I'll give away one final time to one more friend from Chelsea.
My constituent is in a flat where the ground rent is £454 a year, and because it's over a £250 threshold, this means that if they fail to pay the ground rent, their property can be taken away from them. As a result, they have failed to sell this property 6 times, even though they've had buyers. They are stuck in this flat and they cannot get on with their lives. So please, could he look at this particular threshold, because it's causing real problems.
My honourable friend moves me on to my second point that I want to mention. We also recognise the strength of feeling on the vexed issue of forfeiture. The honourable member for Greenwich and Woolwich made a clear case at this committee, as did other members, and I also heard a passionate and eloquent case during committee from the my honourable friend from Walsall North, who is asking to give way one final time.
Will the Minister simply remove any opportunity for forfeiture? It's arcane, it has no place in our system, and I strongly suspect it will get support right across this House.
And the House sees the passion which my honourable friend who demonstrated this at committee is demonstrating again, and both him and my honourable friend from Redditch made such a passionate case at committee. I recognise that this is a real and significant problem, and there is a huge iniquity at stake. I have heard from colleagues about why we should act, both today and previously, and we are working through the detail of this issue currently. We will report back to the House shortly with more details. Finally, there was a comprehensive debate on freehold estates led by my honourable friend, the member for North East Bedfordshire at committee stage, who is a committed campaigner on this issue. And I know many others in this House also have very strong views. As someone who has, I will just conclude this point if I may, as someone who's also been involved in this in places like Alderman Park and Hunnock Grove in my own constituency, I say we understand the strength of feeling on this issue too, and we are considering it further as well. I'll give way to the Honourable Judge.
I thank the Minister for giving way. Residents across estates in my constituency are trapped in extortive relationships with unaccountable private management companies while their estates go unadopted. During the second reading, the Secretary of State expressed a willingness to bring forward and consider measures to make sure residents have a right to manage on these estates at a bare minimum before considering wider action. Is there any reason why the government wouldn't be accepting the new Clause 7 moved today in the name of the shadow front bench to finally give residents on these estates the right to manage and get out of these extortionate relationships?
The honourable member made this case at committee, and I'm grateful for him doing so and to repeat it again today. As I say, we understand the strength of feeling on this issue, and we are considering it further. I will give way one final time, and I'm going to conclude because so that people.
For giving way, these management companies that the Minister alluded to have a literal monopoly over the residents that they are meant to serve. They effectively control the residents rather than the other way round. So I welcome the amendments that were tabled at committee stage to ensure that residents can actually change their management companies. Will he give a commitment to this House that he will ensure that those amendments stay in this bill, both here and in the other place, and that they will become law?
My honourable friend is an absolute campaigner for many years on the importance of this, and I know how strongly he feels and how much he acts on behalf of his constituents for it. We are absolutely committed to making progress on estate management. I think this bill is demonstrating a significant step forward in doing that, and I hope that we will be able to, and we will see what else we can do going forward. I'm going to wind up and to give people the opportunity to speak on this. Madam Deputy Speaker, to sum up, property ownership has been described as being one of the bulwarks of individual freedom. And the measures I've described today are designed to give all homeowners, particularly the younger generation, the chance to gain a proper stake in our democracy. This bill seeks to bring greater fairness, transparency and accountability to the system and give millions of people across the country a more secure foundation to get on in life, a stronger stake in our society and a solid platform for the future. I'm grateful for all members' efforts to improve this bill and for the scrutiny and debate it's received so far. And I'm looking forward to hearing the further discussions to that effect this afternoon.
LPA 1985 Crown application.
The question is that new clause 26 be read a second time. Colleagues will see that there are a lot of members and right honourable members wanting to contribute to this debate, which has to finish at 6 o'clock, and I will want to bring the Minister back for a short time. I would advise, and the other Deputy Speaker is taking over in a second, but I would advise that those speaking from the backbenchers should be prepared for between about 6 and 7 minutes to get everybody in. I'm afraid that's the pressure on time. Shadow Minister Matthew Pennycook.
Thank you, Madam Deputy Speaker. I start by declaring an interest. My wife is the Joint Chief Executive of the Law Commission, whose work in this area I intend to reference in my remarks. I rise to speak to the amendments and new clauses in my name. Before doing so, Madam Deputy Speaker, I'd like to put on record my thanks to all those honourable members who served on the Public Bill Committee for so ably scrutinising the many technical and complex provisions that this bill contains. There were, as you would expect, differences of opinion and emphasis, but it was also evident that there is a shared recognition that the bill can and should be improved further, and an unusual degree of cross-party agreement as to some of the ways that might be achieved. Madam Deputy Speaker, despite reams of government amendments in committee and for our consideration today, this bill remains a distinctly unambitious piece of legislation. That is a matter of deep regret to these benches, not only because the government's paucity of ambition will see exploited leaseholders wait even longer for the current iniquitous leasehold system to be ended, but because it is also manifestly clear that there is widespread support across the House to go much further than this limited bill does. Responsibility for the fact that the bill does not contain so many of the commitments that successive Conservative Secretaries of State have made over recent years, not least in relation to the promised widespread introduction of the commonhold tenure, ultimately lies with government ministers. They had the opportunity to bring forward bold leasehold and commonhold reform legislation, and they made a political decision not to do so. While the opposition appreciate the understandable desire of many leaseholders to see this bill completely revamped so that it lives up to the many weighty promises made by the government since 2017, we made clear at the outset of the bill's committee stage that we did not intend to try to persuade ministers to radically overhaul it by means of the many hundreds of amendments that would be required to implement all the Law Commission's recommendations on enfranchisement, right to manage and commonhold. That remains our position. Whether this bill receives royal assent or not before this Parliament is dissolved, a Labour government will have to finish the job of finally bringing the leasehold system to an end by overhauling it to the lasting benefit of leaseholders and reinvigorating commonhold to such an extent that it will ultimately become the default and render leasehold obsolete. I reassure leaseholders across the country that we are absolutely determined to do so. We recognise, however, Madam Deputy Speaker, that this limited bill will provide a degree of relief to leasehold and freehold homeowners in England and Wales by giving them some greater rights, powers and protections over their homes. For that reason, we're extremely pleased it will complete its passage today, but we're determined to send to the other place the most robust piece of legislation that we can. That means rectifying the bill's remaining flaws and incorporating into it a select number of measures to further empower leaseholders and improve their rights. With that objective in mind, we've tabled a series of amendments and new clauses for consideration today. That they are almost identical to a number of those we discussed at length in committee is a deliberate choice that reflects not only the importance we place on the changes they seek to secure, but the distinct lack of convincing responses from the Minister in committee as to why the government felt it needed to resist them. Madam Deputy Speaker, Part 1 of the bill concerns leasehold enfranchisement and extension. In seeking to implement a small subset of reasonable and proportionate Law Commission recommendations, it is almost entirely uncontentious. However, we do believe that several provisions in this part are defective. We sought in committee to remedy their deficiencies, and a number of amendments we've tabled are an attempt to do so again. Amendments 4 and 5 concern arguably the most significant provisions in this part when it comes to ensuring that the process of extending a lease or acquiring a freehold is as cheap as possible for existing leaseholders, namely the proposed new valuation process as provided for by clauses 9 to 11 and schedules 2 and 3 of the bill. The current valuation method has a number of manifest flaws, and we fully support the new method as proposed in the bill. However, with the applicable deferment rate becoming the primary driver of price to be paid in enfranchisement or extension claims under the new method, as a result of the abolition of marriage and hope value and the peppercorning of ground rents in the valuation calculation, we believe it is essential that it is set in a way that is fair to leaseholders. While the government ostensibly agree, there's nothing on the face of the bill to ensure that will be the case, and we therefore remain convinced that this government, or a future one, could be lobbied by vested interests to set a deferment rate that will be punitive for leaseholders. In resisting our efforts to amend the bill in committee to guard against such an outcome, the Minister argued that the Secretary of State must have flexibility to make decisions on the rate or rates. We agree, Mr Deputy Speaker. We are not suggesting that we buy the hands of ministers by prescribing the rate or rates on the face of the bill. But we do believe that this legislation should be amended to place a clear obligation on the Secretary of State to set a rate or rates with the overriding objective of encouraging leaseholders to acquire their freehold at the lowest possible cost. Happy to give way.
I'm very grateful for the Shadow Minister giving way, and he's absolutely right. The committee stage had a lot of consensus, so I hope he won't mind me probing him on some of the language he's just used about the issue of setting the rates, which we all want to see what the government does on deferment of capitalisation rates. But the Shadow Minister used the term punitive to leaseholders in setting those rates. But does he not accept that already embedded in the issues about ground rents and the changes here is a substantial transfer of value from freeholders to leaseholders, and that the people who are more likely to suffer from punitive behaviour are people who entered into, from the freeholder side, contracts historically, expecting that those values would be considered, and that it is a public policy decision that will change the value in those contracts?
Well, I understand the point that the honourable gentleman is making. He made it, if I'm not mistaken, in committee as well. We very much think the risk is on the other side of the scale, i.e. that a government will be tempted to set a rate that is damaging to leaseholders as a result of being lobbied by vested interests. And while there is a balance to be struck, we think it's absolutely right that we put on the face of the bill that the objective in setting the deferment rate as part of the premium calculation must be to ensure that leaseholders acquire their freehold at the lowest possible cost. Amendments 4 and 5 would ensure that is the case, and I commend them to the House. Mr Deputy Speaker, Part 2 of the bill makes changes to other rights of long leaseholders. It contains the 4 clauses in the bill that implement Law Commission recommendations on the right to manage, several of which we sought to improve, as well as Clause 21 that makes provision for a new enfranchisement right to extinguish a ground rent without having to extend a lease. While we still have absolutely no idea how this clause, or clauses 7 and 8 for that matter, will interact with any proposals that might emerge from the recently closed consultation on restricting ground rents for all existing leases, something that the Minister must provide further clarification on. It cannot be right that we are dealing with such a significant issue at ping-pong stage in due course. But, Mr Deputy Speaker, we very much welcome the intent of Clause 21 and Schedule 7, which it gives effect to. Even if unamended, they will ensure that some leaseholders can enjoy reduced premiums and secure nominal ground rent ownership of their properties without the need to go through the challenge and expense of repeated lease extensions. However, we remain unconvinced by the government's proposed conferral of this new right only on those leaseholders with leases with an unexpired term of more than 150 years. In resisting our attempt to remove the 150-year threshold from the bill in committee, the Minister essentially made 2 arguments. The first was that there was a need to, and I quote him, put a finger on the scale somewhere. In other words, the government take the view that the new right must be restricted based on lease length. The second was that in determining the threshold for restriction, the primary consideration should be which leaseholders are, and I quote the Minister again, unlikely to be interested in or do not need a lease extension. We do not believe that either argument is particularly strong. First, any long lease threshold for the new right is ultimately entirely arbitrary, as evidenced by the fact that the government chose a different threshold than the one recommended by the Law Commission. Second, there's a principled argument that we should trust leaseholders to make decisions based on what is right for them and their individual circumstances, rather than denying a broad category of leaseholders a new statutory right on the basis that ministers know best what is in their interests, a viewpoint we would have assumed that the benches opposite would support. As I put to the Minister in committee, there could be all sorts of reasons why someone with a lease shorter than 150 years might want to buy out only their ground rent, including simply that they are unable to afford the premium required to secure a 990-year lease under clauses 7 and 8. Denying them that right on the grounds that other leaseholders might advertently or inadvertently disadvantage themselves by using the new right to only extinguish their ground rent strikes us as overly paternalistic and misguided. We remain of the view that there's a strong case for simply deleting the 150-year threshold entirely, given that the remaining years test that applies is arbitrary and that the most common forms of lease are 90, 99 and 125 years. Amendment 8 would do so, thereby making the new right to replace rent with peppercorn rent available to all existing leaseholders. I commend it to the House. Part 3 of the bill, Mr Deputy Speaker, contains a wide range of measures relating to the regulation of leasehold. We've tabled several amendments designed to strengthen the provisions in it. Arguably the most important are Amendment 10 and new Clause 3 concerning litigation costs. While we support the aim of scrapping the presumption that leaseholders will pay their freeholders legal costs when they have challenged poor practice, we believe that in merely limiting the ability of landlords to do so, the government are creating an incentive for freeholders to litigate in a way that is likely to erode the general presumption they are seeking to implement. As we argued in committee, a far more sensible approach would be to legislate for a general prohibition on claiming litigation costs from leaseholders, and then to provide for a limited number of defined exceptions to the general rule by means of regulations. For example, in cases in which the landlord is a leasehold-owned company, or in which the costs are, in the opinion of the tribunal, reasonably incurred for the benefit of the leaseholders or the proper management of the building. Taken together, Amendment 10 and new Clause 3 would provide for that approach by leaving out Clause 35 and replacing it with a new clause that provides for a general prohibition on claiming legal costs from tenants and for a power to specify classes of landlord who will be exempted from it. I commend them to the House. Mr Deputy Speaker, we want to see a number of other changes made to the bill to provide leaseholders with better protection in law and to pave the way for a commonhold future. To that end, we've tabled amendments and new clauses to, among other things, abolish the draconian rent charge remedies provided for by Section 121 of the Law of Property Act 1925, provide for mandatory RMCs in new blocks of flats, establish a right to manage regime for residential freeholders on private or mixed-use estates, bring forward legislative options to facilitate leaseholders in new blocks of flats being granted an automatic share of freehold, and regulate managing agents. Of particular importance to us is the need to ensure that this bill abolishes forfeiture and the windfall it provides to freeholders. As we argued in committee, forfeiture is a wholly disproportionate and horrifically draconian mechanism for ensuring compliance with a lease agreement. Over the course of nearly a century, this House has taken intermittent steps to tighten the laws of forfeiture, and yet its continued use and the chilling effect that results from its mere existence continues to put landlords in a nearly unassailable position of strength in disputes with leaseholders. The opposition are not suggesting for a moment, Mr Deputy Speaker, that this House abolishes the right of forfeiture in relation to residential long leases and replaces it with nothing. There must be effective means of ensuring compliance with a lease agreement, and we are more than willing to work constructively with the government to determine what alternative arrangements are needed to deal with breaches of covenant or unpaid arrears. But forfeiture operates to the prejudice of leaseholders. It cannot be justified, and we must use this bill to finally do away with it. We believe there's broad consensus across the House for grasping the nettle and abolishing forfeiture, and new Clause 5 would do so. And notwithstanding the very positive noises we heard from the Minister, I urge honourable members from across the House to support it. Finally, Mr Deputy Speaker, turning to the 100 government amendments to the bill that were tabled last week, 29 of which were submitted just before the deadline on Thursday. In doing so, I feel I must put on record once again the opposition's intense frustration at this government's continued practice of significantly amending legislation as it progresses through the House. The sheer volume and complexity of amendments that this government now routinely tables to its own legislation represents a departure from established practice and one that acts as a serious impediment to honourable members effectively scrutinising legislation and increases the risk that Acts of Parliament contain errors that subsequently need to be remedied. The government amendments that have been tabled to the bill for consideration today fall into three broad categories, namely shared ownership, building safety and new leasehold houses. And I'll take each in turn, starting with shared ownership. While I am increasingly personally of the view that there is a growing case, one that's reinforced by its treatment in this bill, for primary legislation to address various issues arising from shared ownership as a tenure. Government Amendments 24 and 29 that relate to it are not contentious, and we support them. When it comes to building safety, we welcome the government's decision to use the opportunity presented by the bill to make a number of changes to the Building Safety Act 2022 to ensure it operates effectively. Although it must be said, Mr Deputy Speaker, the very fact that ministers are having to completely overhaul arrangements that came into force less than 2 years ago, for example, replacing the existing regime for dealing with insolvent developers and orphaned buildings by means of new clauses 34 and 35, vindicates entirely the concerns the opposition expressed back in 2022 about the way in which the then Building Safety Bill was overhauled at pace via hundreds of government amendments tabled in the other place that noble lords had relatively little time to consider carefully or properly scrutinise. I want to raise two specific issues of concern about the government amendments relating to building safety. The first concerns new clauses 30 and 31. These expand the concept of a relevant defect to which the leaseholder protections in the Building Safety Act apply, and that tribunals can order landlords to remediate. While we obviously take no issue with amendments designed to provide further clarification on how the Act operates, I'd be grateful if the Minister could tell us why the government believes these new clauses are even necessary, given that the President and Deputy President of the Upper Tribunal in the Olympic Village case have ruled that the Tribunal already has the power under the Act to order remedial works in respect of relevant defects, where the works are designed to reduce the risk posed by that defect, not necessarily eliminate it completely. In addition, I'd be grateful if he could tell us why, given the government are clearly willing to act retrospectively, the government will not go further and take steps to guarantee that leaseholder protections under Schedule 8 of the Act apply irrespective of when service charge demands were issued, and thereby prevent the Court of Appeal from potentially overturning the November 2023 ruling of the Upper Tribunal to that effect. The second issue, Mr Deputy Speaker, concerns new clause 32. This expands the categories of costs that leaseholders can seek to recover by means of remediation contribution orders, and will allow for the recovery of costs associated with professional expert services and any temporary accommodation. However, it will not allow leaseholders in buildings with fire safety defects to attempt to recover the significant costs associated with soaring buildings insurance premiums, which in many cases will continue to be levied after remediation works have completed. The government is rightly trying to improve the situation in respect of insurance charges by means of clauses 32 and 33 of the bill. Can the Minister tell us why the government will not allow such costs to be recovered via an RCO? Of course, Mr Deputy Speaker, not one of the 8 government amendments that relate to building safety resolve the underlying problems with the government's approach to it, namely the detrimental impact of the decision to exclude certain categories of leaseholders and buildings from the protections that have been afforded to others under that 2022 Act. As such, we've tabled new clauses 9 and 10 that would give the Secretary of State the power to bring non-qualifying leases and buildings, respectively, within the scope of the protections of the Act, and I commend them to the House. Turning lastly to new leasehold homes, Mr Deputy Speaker. The government was rightly mocked in the aftermath of the bill's publication for claiming it ended leaseholds on newly built houses in England and Wales when it contained no such provision. On Thursday, the government finally tabled amendments that appeared to finally make good on their promise. There's only one problem, Mr Deputy Speaker. The government's purported ban on new leasehold houses doesn't actually ban all new leasehold houses. Indeed, it is unlikely in our view to even ban most of them. That's because new Schedule 2 would still allow new long residential leases of houses to be created in instances where a superior lease has been granted before the 22nd of December 2017. Now, the Minister suggested in his opening remarks that the government were thereby only allowing the sale of new leasehold homes in all but unusual circumstances. But this is far from a limited exception being introduced. We literally have no idea, Mr Deputy Speaker, how many undeveloped plots of land and properties within them might be subject to such superior leases, or how many could still be granted subject to agreements made under such terms. For example, where a developer has purchased a pre-2017 head lease on a site but has not built it out. But given that we know that developers routinely use intermediate leases both for financial purposes and to insulate themselves from various consumer rights and protections, the prevalence of such arrangements in the leasehold housing market is likely to be very high. As such, while we understand the significance of the date in question as the moment when the policy was first announced, and appreciate the need to provide for a limited number of exceptions, such as National Trust properties, surely the government realised that the exceptions provided for by new Schedule 2 are likely to render the ban meaningless and will see new leasehold houses still built in significant numbers. Mr Deputy Speaker, I have no doubt that the other place will have much to say about these new provisions, but the Minister owes this House an explanation today as to precisely why the government have potentially afforded developers a means to continue to build new leasehold houses in significant numbers. In providing that explanation, I'd be grateful if he would tell the House why on earth leasehold retirement properties have also been exempted, given the almost uniformly detrimental impact of such arrangements on older people living in them. To conclude, Mr Deputy Speaker, this unambitious piece of legislation is a far cry from what millions of leaseholders were led to believe would be forthcoming, given the extravagant promises made by successive ministers over the past 6 years. They nevertheless recognise, as we do, that this limited bill will provide them with some relief from the unjust and discriminatory practices that our archaic leasehold system facilitates. For that reason, they share our desire that it receive royal assent as quickly as possible, but we owe it to them to deliver the most robust piece of legislation that we can. We have a chance today to strengthen the bill in a number of important respects, to rectify aspects of it that are problematic, and to improve it by incorporating a small number of targeted measures that will immediately empower leaseholders and improve their rights. I urge the House to come together to do so.
Thank you very much. I'm sure everybody heard Madam Deputy Speaker's request for brevity, as a number of members do want to get in, and we hope to accommodate everybody before 6 o'clock. Sir Peter Bottomley.
Mr Deputy Speaker, I agree with a large part of what the spokesman for the opposition said, and I agree with nearly all of what my honourable friend had said. Where I disagree with the honourable member for the opposition, I think it is ambitious in what it's trying to achieve. We'd all like it to go further, but it's quite remarkable that since 2002, there's the first major bit of legislation helping leaseholders. We've had the Building Safety Act, the Fire Safety Act and other things which did something to do that. But it's still remarkable how few people know much about the role of residential leaseholders. They own nothing. They own the right to live in a home for a period. I declare that I am a leaseholder. I've got a flat in my constituency where there's been no problem and where this bill will do no harm and no good. And I also have another leasehold property where if I happen to get a benefit, I'll give it to a good cause. So I'm not here for myself, I'm here for those who've been suffering for years. I have another conflict that I wish I could be at the debate on BBC impartiality, because it's now 20 years since the peace activist and photographer Tom Herndel was shot by a sniper in Rafah, and the next 9 months of inquiries by the IDF were shocking. But I'll leave that to another debate. On this, I believe that we have opportunities, both in the House of Commons and perhaps more in the House of Lords, to make significant progress. My honourable friend, the Minister, would point out to me the consultation that started on the 13th of February about permitted development rights, where towards the end, in the paragraphs 43, 44, 45, construction of new dwelling houses on freestanding block of flats, is a reference to the unexplained, disastrous statutory instrument 2020-632, which allowed, under emergency COVID regulations, and with an economic assessment, which bluntly, if I were a better economist, I would have been ashamed of, which allowed owners, landlords, freeholders of certain blocks to put an extra 1 or 2 stories on top without consulting the existing leaseholders at all. How any government, let alone one I support, could have done that is beyond my comprehension. There had been a consultation some years before. The general conclusion was don't do it. So why has it been done? I hope that people will look at the consultation open until April, answer the questions, I think it's 20, I can get the right page, 27 and 28, but also give explanations of their own experience. In St Andrew's Gardens, in my constituency, a developer tried to put extra floors on top, turned down flat by the local authority, turned by the government's inspector on appeal, tried again, and have now come back advertising for sale flats that don't exist, where nobody wants them and will have significant harm. My new clause 25, and I'm indebted to Liam Spender of St David's Square in East 14 for drafting it, will say that the landlord or developer will have to pay compensation to leaseholders for the effect on them, if it's deleterious, if it's harmful to them. Now, the Minister's legal advisers might say it's not a perfect draft. I think it's a pretty good one. So if the Minister will allow me to say so, even if he can't accept it now, will he still go through the replies to the consultation, have a talk with those who represent those affected, that's people on all sides of the House, and see whether the government can consider coming forward in the House of Lords with proposals which will undo the effect of 2020-632 and which will implement some of the preferred responses to the consultation to which he may not be able to have time to refer in his winding up. I turn to one or two other short points. One is there is still no requirement on utility suppliers or insurance companies to let the tenants, the leaseholders who are paying, know what commission is being paid to managing agents or landlords, on the grounds that they're not party to the contracts. We must make it clear by law that each residential leaseholder is a party because they are paying. I can't think of any other example where people are contracted by law to have to pay for something where they don't know who's getting a rake-off or a commission or an inducement on the way through. It seems very clear and simple. I turn to forfeiture. There will be problems, even if you have leaseholders who own their own freehold, when some leaseholder doesn't pay. And you need to have some way in the end of requiring them to. And that may require going to court and saying that the property should be sold and the debt paid off. The question really comes, who gets the free-floating equity, the money that's left? At present, it goes automatically to the landlord/freeholder. And there was a scandalous case I was involved in Battersea, where someone over a debt of less than £10,000 was liable to lose hundreds of thousands of pounds of equity, until I managed by the one thing that MPs can do, which is draw publicity to an issue, to get various people to pay attention and wake up and save the situation. The law must be changed, either by common law, or senior judges laying down the law, or by statute law, which would be better, saying in the circumstances where someone's leasehold interest has to be sold, the remaining equity goes to them and not to somebody else. It's not a very complicated issue. There's no legal justifiable, no commercially justifiable argument why that shouldn't happen. And I asked the Minister to make sure it does happen. He'll get my support, and I get support across the House and in the House of Lords as well. There are many other issues which matter. Can I commend the people who provide the Secretariat to the all-party group on Leasehold and Common Hold reform, that's the Leasehold Knowledge Partnership, and their trustees, who've worked, many of them for no money at all, and others for a pittance, to try to help the House get on with the duty we need to fulfil ourselves. I leave with a final point, which is in homes for the elderly. I don't believe that we have enough. We ought to have not 5%, but say 15%. And if people have the confidence to choose to go into a home which has been developed probably in the centre of a village or a town or a city, where there's no major opposition from neighbours to have that kind of development, where people know others who will go at certain periods of their life to choose to live in a place where someone else looks after the roof, where it can be thermally efficient. I have, for example, a relation who moved to a home in Taunton, and I don't think they put the heating on in 5 years because it's so thermally efficient. Instead of staying in a cold, damp house with the roof leaking and the basement rotting and the like. I think if people could have confidence they weren't going to be exploited by a loss of value, if they're confident they weren't going to have operators who would give the appearance of ripping them off, and a repeat of the kind of scandals which the Cengiz interests were involved in 20 or 30 years ago, when call systems were renewed at exorbitant prices when they probably were working fine, then I think you'd find an extra 10% of homes available to others who, during their lifetime, during their housing tenure, can have better homes and easier homes. So let's give people confidence that at all stages of their lives they can be safe living as tenants or as leaseholders or as freeholders, and that we take away some of the worries and the problems which law can deal with, practice can deal with, and public information can deal with as well.
Very much. Clive Betts.
Thank you, Mr. Speaker. Referred back to the Select Committee report on leasehold reform. It's now 5 years since that committee reported. It came after long years of campaigning from the all-party group, and I particularly commend the efforts of the Father of the House who's just spoken, my other friend, the member for Ellesmere Port, and our good friend Jim Fitzpatrick, who's no longer in this House, but certainly made a major contribution to that. I'll be fair to the government. It's good that we have now made progress on many of the items in the Select Committee report. The caveat, of course, is we probably haven't gone as far as we would have wanted or as quickly as we would have expected. When we met as a committee, I remember going in a room with around 100 leaseholders from all over the country. And the Honourable Member for Harrow East, who was in his place just a few minutes ago, was in the room as well, along with other Select Committee members. We heard horror stories of people being ripped off in the sale of leasehold homes by developers. They were told there was no difference between a leasehold property and a freehold property. They were told that by the solicitors who worked for them, because solicitor was recommended by the developer, together with the free carpets in the living room that came with the bribe, because that's what it was. They weren't aware that they were going to pay £300 to get a doorbell bell fitted if they wanted one, because they had to get permission, or £3,000 for a conservatory, or whatever fees the freeholder chose. And they were told within a couple of years, of course, they could buy the freehold at a fixed price from the same developer. The problem was, of course, by the time it came to inquire about purchasing the freehold had been sold to another party. Yeah. And there's lots of experience and examples of that. That's why I got an amendment which I want to push to the vote, but I hope the Minister will accept it. It's a simple amendment to say that before there's a sale of a freehold, the first right of refusal has to go to the existing leaseholder. That right already exists for leaseholders in flats, but not for leaseholders in houses. I mean, why is that? That's really something that can't be justified or even explained. Will the Minister just accept that one simple amendment? It will give that right and stop what happens, and we know it happens. Freeholders who want to evade the legislation, including the improvements the government are bringing in, from passing the property around from one organisation to a subsidiary to another third party with a view to evading the legislation. So the leaseholders never know where to go to actually get the relevant freeholder to actually agree the sale. Of course, I give way.
Thank you. Which you intend to. Speaker, my honourable friend is making an excellent speech. Does he agree with me that part of the problem is that some of the freeholders are based overseas, and it's extremely difficult for leaseholders to track them down, and this is an ongoing issue which I hope the government will look into?
Absolutely. I hope the Minister would have a look at the whole issue of freeholds that won't respond. And that could certainly applies to many who are overseas, who it's very difficult to get in touch with. So I put new clause 40 down, which I won't push into a vote, but it's really to come back to say to the Minister, the default answer can't be, well, the leaseholders can always go to the tribunal, because most leaseholders are simply ordinary residents trying to get on with their lives, who think that it ought to be fairly easy to put in a request, get a calculation done, and buy their freehold. They're not ready for those organisations with all their lawyers and their surveyors who want to evade this and try and hide away, if in some cases overseas, so they can't be contacted. Can the Minister just have a look at that challenge? I know he's aware of it. We share the same problem with Copland Estates, but there are others who are based overseas. These are based in a shop front that's semi-boarded up with a letterbox that never seems to get opened. And that's the sort of company you're dealing with. They're small organisations who make a living out of charging ground rents from leaseholders who then can't actually exercise their enfranchisement because of the attitude and evasion of the freeholders concerned. So I hope the Minister would come back and have another look at that particular issue. The other amendments I've put down, are about having professional qualifications and some form of regulation of property managers. Now, on social housing, the government's just legislated to say that the managers of social housing will have to have professional qualifications in future. So what's the difference between a manager of social housing and a manager of leasehold blocks, a property manager? In some ways, there may be greater complications in trying to manage a multitude of different leaseholders than people who have all got secure tenancies in a council or a housing association block of flats. Now, what is the difference? Why will the government just not recognise that there are some good property managers who are well qualified, experienced, and can be held to account, but others aren't, and they're put in place for that purpose because they're cheap, they don't have experience, they don't have qualifications, and they're another way of avoiding the restrictions and rules that are rightly put on the management of property, so they don't bother with proper service charge information or proper lists of charges for permission fees, which the government has tried to improve, and I accept that. But in the end, they're only going to work if the individual or organisations managing the property are going to do it in a proper way. So I just say to the Minister, have a look at those as well. What is the rationale? What is the resistance to making sure people doing a serious and important job as property managers are actually qualified to do it and are properly held to account through regulation?
Thank you very much. George Eustice.
Thank you very much, Mr Deputy Speaker. And can I begin by declaring my interest as an advisor to the HSPG Group, which among other things is a registered provider of social housing. But I rise this afternoon to speak to my own new clause 68, which is based on a specific challenge that I've encountered in my constituency, affecting residents in over 70 homes spread across 3 locations in the town of Hale and the village of Mount Hawke. And I think that the experience of these particular cases exposes a potential gap in the current bill, a gap in policy, and that is around the issue of shared ownership. For while this bill deals at some length with standard leasehold agreements and the problems of extortionate ground rents, and it deals as well with some of the issues around service charges and management companies that we're all familiar with, it is the case that in the early 2000s there were some agreements that were put together that were technically leasehold agreements, but which masqueraded as shared ownership agreements, even though those shared ownership agreements do not comply with the standards of modern shared ownership agreements. And there's a number of defects in the agreements that I've encountered, which I would like the view of the Minister on. The first is that the leasehold in these cases, the freehold on these homes, is not held by a registered provider. It was initially owned by the developer who built these sites. It's changed hands twice, and in a way that's familiar to many members here, it's actually ended up in the hands of an offshore investment vehicle based in the British Virgin Islands, a company called Rockwell, which has not been very easy for residents to deal with over the years. The second major defect in these agreements is that there is no provision at all for staircasing or enfranchisement of the residents, the leaseholders' share of the property. Residents typically own between 58 and 72% of their property, but their stake is fixed and cannot be extended. There is no right to extend under the agreement. And these are under a 990-year lease. Again, no ability to extend, although I appreciate it's a long-term lease at 990 years. The third defect is that even if those residents could enfranchise and extend their ownership, staircase, if you like, within the agreement, there is a Section 106 covenant on those, which means they must be sold to a local connection at a significant discount to the market value. And the way that has been worded in the agreement means that it is simply not worth the while of residents to increase their share, since there would be no value to the increased share that they would have. And finally, there was a ground rent, as it was described, but in practice, a big chunk of that ground rent was effectively a rent on the shared ownership portion. There was a ground rent initially of around £20 per week, but this was linked to RPI on a escalating model. It's now got close to £2,000 per year for those residents, and it's still increasing rapidly. Now, all of these defects in the agreement, in that leasehold tenure arrangement or shared ownership arrangement, or indeed the fact that it appears to be neither one nor the other, means that all of these properties have been judged unmortgageable by lenders. And that means that these residents are trapped. They cannot sell their properties because nobody can get a mortgage to buy them. And Mr. Deputy Speaker, these are people in my constituency who had a local connection, typically people who are on modest incomes, and these agreements and these homes were sold to them as a way to get a foot on the housing ladder. And I have to say that for those residents, this has transpired to be a complete nightmare for them. Now, I want to say a word about planning and to pay tribute in particular to Penwith District Council as it was then, but also Cornwall Council, because planning for these was granted between the years 2004 and 2006. And actually, the local planning authorities did their due diligence. They could see that this shared ownership model was defective, and they refused planning permission on all 3 sites on that basis. Now, the Minister might ask, how then did these homes get built and sold under this? But I suspect he also can predict the answer, and that is that they were approved at appeal by the Planning Inspectorate, an agency within his own department. So the situation that my constituents face has been caused principally by a chronic failure of due diligence by the Planning Inspectorate, as is often the case in some of these issues. So my new clause 68, in conclusion, Mr. Deputy Speaker, seeks to address this gap in the bill, and it seeks to give the opportunity to government to atone for the mistakes of the Planning Inspectorate. It deals explicitly with the issue of shared ownership agreements. It creates a statutory right to staircase ownership, and it creates a cap on the rent of the freeholder's portion of the home. Now, I don't intend to push New Clause 28 to a division this evening, but I do hope that the government will consider this very closely. I would like to meet the Minister or the Secretary of State and to share with him and his officials a copy of the agreement that exists, this shared ownership agreement that my constituents are suffering so much under, with a view to seeing whether the government might consider further changes at later stages of this bill to address what I believe could be a gap in this. And I hope that, given that the Planning Inspectorate have been somewhat culpable in creating this problem for my constituents, that the government will seek to do that. I support the general thrust of this bill in all its attempts to deal with management charges, service charges, and its attempt to deal with the issue of ground rents. But I hope that the Minister will agree to meet me to discuss some of these remaining issues.
Thank you very much. Barry Gardiner.
Thank you, Mr. Deputy Speaker. It was the 1st of December 1998. I'd been an MP for 1 year and 7 months to the day, and I was chained to the railings of College Green by 200 cheering leaseholders. Thankfully, they were friendly. It was to illustrate that leaseholders feel that they are in prison. It was the days before social media, and it was a photo op. And the BBC ran the headline, "Leaseholders demand more control." They still do. Since then, we've had the Common Hold and Leasehold Reform Act, which was an attempt to resolve some of the problems, such as forfeiture of a person's home for failure to pay a small service charge, the ground rent grazers charging money for no service, and monies not being held in trust in sinking funds. Strange, then, that after 25 years, these should be the very areas that yet another bill on leasehold reform is pretending and failing to solve. I say failing because that's the reason I rise to support my honourable friend's new Clause 5. It's ridiculous that a landlord can take away a person's home worth hundreds of thousands of pounds for a simple failure to pay a minor service charge amounting to a couple of £100, and where there is a dispute over whether the service was even provided or not. It's why I put forward new Clause 16 about monies being held in trust. This would implement a provision of the 2002 Act, which has never been brought into force. We heard at committee that this policy had strong support from stakeholders, including spokespeople for the Property Institute and the Leasehold Advisory Service. Even the British Property Federation has campaigned for this provision of the 2002 Act to come into force. Yet it's not here on the bill. Of course, 2002 was a time when nobody had even predicted the new rentier practices that freeholders and developers have since invented to extract money from homeowners for the privilege of living in their own homes. The scandals of leasehold houses, the doublings, the repeated doublings of ground rents, the inclusion of commercial areas and shared services in any development to stop any hope of residents exercising their right to manage. My new Clause 17 would enable and ensure that leaseholders in mixed-use buildings can take advantage of the government's policies to lift the 25% non-residential premises cap to 50% and to have mandatory leasebacks on expensive commercial premises. Unless this is adopted, or a version of it, I fear very few leaseholders in mixed-use buildings will be able to collectively enfranchise under this bill, which would be a travesty. If government doesn't decisively address the structural dependency rules, not only for enfranchisement, but right to manage too, property developers will simply sidestep the new 50% non-residential premises limit by designing mixed-use blocks with shared services connecting flats to commercial premises by an umbilical cord to deny leaseholders their rights. Indeed, there have been articles in the past from leading law firms explaining how developers can build sites to ensure blocks can never be eligible for collective enfranchisement and right to manage. My new Clause 18 would provide the appropriate tribunal with the discretion to dispense with certain procedural requirements where it's satisfied that it's reasonable to do so. It's designed to deal with cases where a landlord attempts to frustrate a right to manage claim by procedural means. And I'm grateful to Mark Loveday of Tranfield Chambers for his help in drafting this new clause. He is perhaps the leading authority on service charges and right to manage practising in Britain today. By Mr. Loveday's count, of the Law Commission's 101 recommendations on right to manage, fewer than 5 have been specifically adopted by government in this bill. There is a whole industry that has now emerged since Labour introduced the 2002 Act that brought right to manage into existence, whereby freeholders seek to find minor technical errors by leaseholders to scupper genuine and otherwise valid right to manage claims. Since right to manage is a no-fault regime, Parliament never intended for it to be an invitation to litigation by deep-pocketed freeholders and their army of lawyers. The 2002 Act's right to manage does have traps for the unwary, as Mr. Loveday notes. The single most important problem with the right to manage, namely its procedural complexity. With these problems, famous amongst property lawyers, that have notoriously led to litigation on a truly industrial scale. I urge the Minister to look again at my new Clause 18 in the other place and adopt this pragmatic amendment which would ensure that a tribunal can waive minor procedural mistakes by leaseholders where it deems it is just and convenient to do so. Since 2002, we've also had the Grenfell Tower tragedy that has exposed the rotten culture of residential construction in this country. Members should wonder why it is that over 11,000 tower blocks in this country are reckoned to have fire safety defects, no fire stopping in building voids, a lack of compartmentation, combustible cladding, inadequate fire doors that leave residents at the mercy of landlords who literally go to the other side of the world to avoid having to pay for remediation. Residents are subject to unfair service charges and find themselves literally prisoners trapped in their own homes, unable to sell up and move on with their lives. This unjust system leeches off ordinary people and shames us, the only remaining country in the world where residential leasehold is the default tenure for apartment living. Your home should not be a source of misery to you and unjust enrichment to others. We're talking about the lives of 5 million people who need to be freed from their feudal burden. And this brings me to my new Clause 19. which seeks to restore the intent of Section 20 Major Works regime in the 2002 Act to what it was prior to the Dejan ruling. The Minister was good enough in committee to confess that he was unaware of the ruling and said he would study it with his officials. And yesterday I received a letter from the Minister on some of the points I raised at committee. He admitted that since Dejan, the vast majority of applications for dispensation are brought by the landlord, but goes on to say that, however, regardless of which party makes the application, the landlord will have to persuade the tribunal that dispensation should be granted, and it will be for the leaseholders to evidence that they have suffered prejudice. He said, I consider your concerns that leaseholders have to evidence prejudice, but only they are able to do so. Once that threshold has been met, the burden is on the landlord to rebut the impact the prejudice has had on leaseholders. He concludes, the consequence is that an application to the tribunal is not merely rubber stamping the landlord's request. I'm afraid I fundamentally disagree with him. Sue Bright, Professor of Land Law at Oxford University, has been conducting academic research into this area, and she argues as follows. The importance attached to the consultation requirements is evidenced by the fact that if the landlord fails to conduct the statutory consultation, it is prevented in the current form of the consultation provisions from recovering more than £250 from an individual tenant in relation to those works. Seemingly, this provides a very strong incentive to comply with the requirements, but the protection offered was seriously weakened by the Supreme Court decision in Dejan Investment Properties Limited v Benson. Lord Neuberger said the consultation requirements are a means to an end rather than an end in themselves. He sees the provisions as playing a supporting role in achieving only the end goal of consumer protection secured by Section 19 of the Landlord and Tenant Act 1985, that is, protecting tenants from unreasonable service charges. An alternative vision, supported by the dissenting judgment of Lord Wilson, acknowledges that consultation is an important end in itself. This recognises that consultation has an inherent value. Further, it's in keeping both with the tenor of the new building safety regime that promotes fuller engagement with leaseholders and residents and the thrust of contemporary government policy towards providing consumer protection to leaseholders. Her findings are grim for supporters of leaseholders and a sense of fair play. She says in all of the fire safety cases reviewed for this article, dispensation was granted at least in part, and with a few exceptions. The overwhelming majority were granted unconditionally, even when the first-tier tribunal was critical of the way in which the applicant had managed things. I'd also like to thank Dr. Howard Soper, another academic who helped draft the amendment, who was appalled at the number of successful dispensations won by freeholders that he found in his study of first-tier tribunal decisions. I would urge the Minister to think again, as this cuts to one of the most fundamental injustices that we've seen in leasehold apartments in recent years, those individuals who are trapped in buildings with fire safety defects. The Leasehold and Freehold Reform Bill is the first set of reforms to the leasehold tenure in 22 years. The test that I set then Labour administration was a simple one. I said, what we want is for leaseholders to be able to take control of their own lives without landlords being able to say when you have a new roof, how much you pay for it, who does it, when it's going to happen. You should be able to decide that for yourself in your own home. I believe the proposals in front of us today do not liberate leaseholders. The Secretary of State himself said, I don't believe leasehold is fair in any way. It's an outdated feudal system that needs to go, and we need to move to a better system and to liberate people from it. He was right. This bill doesn't do it. It will be left to a future Labour government to do so.
Very much. Neil O'Brien.
Deputy Speaker, there's lots of good things in this bill, and I really give credit to the Minister and previous Ministers for bringing it forward, and indeed to my honourable friend from North East Bedfordshire, who has played a massive role in bringing this to the House. It effectively bans the sale of new leasehold houses through the new Clause 42 that we've been discussing today, extends leaseholders' rights in various ways, increases transparency of leaseholders' service charges. But there are two big things that it still needs to do that we need to strengthen in this bill, which we have been talking about in Bill Committee and through this report. And the first of them is to end the Leasehold Estates model. New Clause 1 and New Clause 2 and 6 and 7 are relevant to this here. I was very glad to hear the Minister, who I know understands this, talk about going away and considering this further. But for the benefit of the whips, what my constituents want is not to consider this further. They want the Minister to ride in like a new sheriff on a white horse and sort out the fraudsters, scam artists and various cheats who are making their lives a misery. That is what we want on this side of the House. Leasehold estates are just like the post office scandal, except that they affect more people. In considering the post office scandal, many people have said, how could we have known about this injustice for so long? It ruined so many people's lives and nothing was done for so long. This is just the same thing. Now, in my state, in my constituency, we have lots and lots of these new estates, and often the first thing that people know about them is when a massive bill comes through the door. Now, they didn't realise it was coming, they didn't see it in the notes when they bought their house. They were often encouraged to use the lawyers of the people building their house, who didn't, funnily enough, draw it to their attention. And some of those bills are really scary in size, and they often escalate very quickly over time, and a huge number of people are now affected, more and more of them every day. We know there's about 20,000 estates affected, between 1 and 1.5 million homeowners, so maybe 3 or 4 million people. And according to the Competition Markets Authority over the last 5 years, 80% of the freehold properties built by the 11 biggest builders have been through this leasehold model. And a lot of my residents describe it as like paying a second council tax. That's just what it's like. Except if your local councillor, if you don't think they're doing a good job, you can kick them out. With your leasehold landlords, you can't, no matter how badly they perform, and something that New Clause 6 suggests addressing, which I hope that the government will address as this bill moves forward. I think everyone now knows how the leasehold scam works. Back in the good old days, the builder builds their new estates, they make sure that all the roads and so on are up to spec, they pay Section 106, and the council takes it over and then runs it, and if there's a problem you can contact your local councillor. Under the leasehold model, it's not so simple. Effectively, there is collusion between the council and the developer, and so the developer agrees to hand over the running of many parts of the estate, be it the roads, be it the verges, be it other facilities, to a different company. They might own that company themselves, they might hand it over to the residents, and effectively the developer gets to pay less in Section 106, the council doesn't have to maintain the road, and effectively they are splitting the profits while the residents and the new tenants get the new massive bill. Now, running things in this way in the real economy is extremely inefficient. In one of my estates, I see, in most roads, the council go around from road to road with their verge cutting, lawnmowers. It's, one system, it's simple. But on leasehold estates, there's one of them where a guy drives down from Oldham, which is like 2 hours away plus, mows one tiny bit of lawn and then goes away again. So this is economic madness. I mean, a lot of the charges that people are hit with are opaque management fees for nothing really. But in the real world, there is also an inefficiency about running things in this way. And there is a ticking time bomb here, as well as the numbers of people affected by the leasehold estates scandal. There's a second problem insofar as, because these things aren't being adopted, they don't go through that gateway where we check that they are up to scratch. And so a lot of these things, I know from the experience of my constituency, are done badly, and then they will land a huge future bill on the people on these poor estates to sort out these problems in the future. Now, during the Bill Committee, we heard all about this. I'd like to pay particular tribute to Harry Scoffin, the work of the group Free Leaseholders, the residents group Hornet, the Homeowners' Rights Network, who all made a very powerful case to abolish the leasehold estates model entirely. And as one of the witnesses in the Bill Committee said, this is my property, it's my hard-earned future. Normal house buyers are not qualified to manage estates. If we're given the right to manage, we're looking at a development of over 100 homes. It's really hard to get in touch with 100 people who will all agree and be on the same page. It's just not workable. And just to give you a few examples from my own constituency, Mr. Deputy Speaker, I want to talk about Karen. Karen is a brilliant lady who does lots of work for her community, and she moved into a new barrack home because she was bored of doing loads of DIY every weekend on her old home. But instead, she finds herself spending massive amounts of time fighting a leasehold company called Firstport. And they are so notorious, by the way, that there is a national action group, and I commend to the House the work of the national action group on Facebook against Firstport. And she explains, Barrett's encouraged us to use their conveyance solicitor, in return for which we got £500 off our legal bill. We were fools to do this, but money was tight. Firstport didn't arrange any grass cutting or anything by way of service for the first 2 years. First, the bill was £35. This year, it will be £74. Our bill for the year includes property damage, public liability insurance, terrorism insurance, grounds maintenance, general maintenance, first pot's management fees, the biggest item by the way, audit, external accountant's certificate and fee, general reserve, health and safety risk assessment, and this all comes to £74 per home. She says, in the months of December, January and February each year, I must spend more than a couple of days a week doing this. It's like having a part-time job. I didn't move to face the possibility of having to be the director of a residents' right to manage company. I want things to be adopted by the local council as it used to be. And she is right. She is right. And you might be asking, why are residents in this state having to pay terrorism insurance for offence? And that is a really good question to which I don't know the answer. If I can introduce you to another of my constituents, there's also James, brilliant, hard-working constituent of mine, very brilliant. He's had to do tons of work on his estate. And he says, councils should be adopting new estates. I've done about 50 days' work over the last couple of years. We moved in 2018 and it wasn't sorted at all until 2021. In fact, it's still going on. If I hadn't been proactive, we'd have been short-changed. I can also talk about the residents in Hursley Park. They've had no end of problems with their developer, who is currently refusing to even meet with them, by the way, to discuss some of the problems. Paths have been done on the cheap, they've become a quagmire, the benches have not been done properly, and due, fortunately, to a legal error by the developer, they've managed to actually get control over the Residents' Management Committee. But still, after 3 years of effort, trying to get the developer to make good these problems so they don't face years of bills in the future, they are still fighting. And many of them don't really want to be running their own estate. They shouldn't have had to do that. And there's a last example, I just want to mention Farndon Fields. It's a new estate built over the last couple of decades by multiple developers, including Redruth and Avant. And the courtyards and shared spaces in that development weren't adopted by the council. Astonishingly, each individual tiny little courtyard was run as its own financial entity and then managed by a company called Chamonix, who turned out to be almost extraordinarily difficult to contact. And each year they were forced to pay maintenance for a couple of minutes' work over a whole year. And one of my constituents wrote to me, on one occasion I was continually asked to pay an invoice which I'd previously already paid, despite sending proof of payment 2 or 3 times. I was told court action would be taken. I replied welcoming this and advising them that I would counterclaim for stress and for my time. I then received an apology letter from the financial director. I'm now fighting a charge for work for £376. Thankfully, managed company there, the residents managed to wrest back control off the company after a huge amount of effort, and that was just as well because Chamonix has now been bought out by First Pot, so they've had a lucky bullet. I could go on and on, from charging residents for terrorism insurance for offence, to ripping out new planted trees, to charging residents for work that never happened. The absurdity of the leasehold scam is apparent to everyone who has encountered it. And there's multiple ways we can solve this. Partly, we need to solve it for existing residents. That involves some sort of right to manage, much clearer ability to get control of your own estate. But in the future, we also need to stop the model in the future. We could take up the brilliant proposal of the Honourable Member for North East Bedfordshire to prevent management companies taking on services that are normally provided by local councils. We could take up the suggestion made by Councillor Sean Gunner, the leader of the Conservative group on Arran Council, to change the government's guidance on the use of planning conditions, which currently states that conditions can't require that land is formally given up and ceded to other parties. We could change guidance to make it difficult to go down the leasehold route. Whatever we do, we've got to get rid of this scammy model that is bringing misery to the lives of my constituents. The second thing we've got to do is to end forfeiture, as suggested by new clause 5, and also by the Minister today. I'm really glad that he is talking about getting active on this. Margaret Thatcher told the Conservative conference in 1982, there is no prouder word in our history than freeholder. And she was right. The idea of property ownership has a long history on this side of the house. But a lot of people who are buying freehold properties are in fact being conned. It turns out they don't really own the properties at all, and if they fall even a little bit behind on their bills or refuse to pay some scammy leasehold company a small amount of money, they risk not just having to repay or to pay the costs as well, but losing their house. And it is that threat that enables the leasehold cowboys to get away with it. They are terrorising these people on threat of the loss of their house, and we've got to end this. As Mrs Thatcher said in her final book, everyone involved in the country's economic life has to be protected against extortion and corruption, and that is what leasehold is. We've got to end it. So, the final small thing we've got to do in this bill is to start the turn away from ground rents. And I use that word advisedly, turn away. Ground rents are payments not in return for any service. The historical rationale for existence is totally obsolete. In 2018, the survey found that about half the people who face these escalating bills didn't realise they would be on the property when they bought them, and it causes huge problems in terms of remortgaging. I get that there are problems, I get that there are challenges, in terms of having to move away gradually from this model. But we should start to stern the supertanker now. These are pure economic rents. These are pure rentiers. It is a totally unfair system. We might have to move slowly, but we've got to start the movement away from these ground rents grazers, because it is an unfair system. It doesn't have any rationale at all. I know the Minister understands the issues, and I just encourage him on all these issues. Let's be brave. Let's solve these problems. There hasn't been legislation on this since 2002. This is our one chance. Let's really go for it. Let's have conservative principles, and let's end these massive rip-offs.
Lynn Brown.
Mr Deputy Speaker, I rise to speak to New Clause 3 and Amendments 12, 13 and 14. Huge numbers of new builds have been built within my constituency boundaries over the last months, the vast majority of which have been flatted. There have been numerous difficulties over the past years, much of which I'm not going to be able to cover today due to the time limit and your exhortation, Mr Deputy Speaker, to stay within 7 to 8 minutes, which, as the first woman to speak, I intend to do so. I'll start with Legacy Wharf in Stratford, where leaseholders have been struck with a succession of management companies that fail them time after time after time. Under the former management company, shoddy, probably overpriced repairs were made by favoured companies at leaseholders' expense over and over again, rather than any investment in long-term, high-quality maintenance. There was a huge suspicion by residents about possible kickbacks from service firms to the management company and the use of companies under the management company's ownership rather than seeking the best price and the best quality of service. That management company has thankfully changed, but many problems remain. Residents were just handed bills for 18 months of energy all at once due to the management company's mistakes. Service charges, insurance bills rocket year after year after year, with residents wondering what on earth has actually been done with their money. Poor landscaping, broken lifts, inadequate fire doors, security of communal areas is rubbish, loss of hot water access and boilers that haven't been serviced in as long as 4 years. All serious concerns raised from just one building. And ultimately, when accountability is sought, there is absolutely no way to get a prompt response. When there's such a constant deficit of transparency, it inevitably looks like a way to cover up wrongdoing or mismanagement, incompetence. So I strongly welcome the provisions in this bill on service charge transparency, and I want to add my support to the opposition amendments in the name of my honourable friend, the member for Greenwich and Woolwich. Amendments 12 and 13 would surely provide additional support to my constituents, because it would mean that leaseholders wouldn't have to pay service charges unless basic transparency and accountability was in place. Amendment 14 would enable a maximum cost to be set for the provision of information to leaseholders, preventing the abuse of such costs to effectively obstruct accountability. It ain't on. Leaseholders in every part of West Ham have faced massive difficulties getting that very accountability. I'm reminded of events in Canning Town in the Hallsville Quarter development, where residents across several buildings had to leave their homes after a sewage ingress and power cuts. The two different management companies responded in totally different ways. Granger offered £50 a day in subsistence payments, whilst First Port initially offered just £15 a day and only raised it to £25 after enormous pressure. First Port had to be chased by me for multiple basic actions and responded so poorly to residents whose lives had been turned upside down by problems absolutely not of their making. Next, I'd like to raise the continuing concerns of the residents of Chobham Manor about the estate charge, which has increased rapidly over recent years. The charge is supposed to pay for the upkeep of Queen Elizabeth Olympic Park, but many residents on Chobham believe it bears no relationship at all to the amenities that residents nearby the park receive. Despite my support, they've found it almost impossible to scrutinise the budgets that they're paying for and to make sure that they ain't paying through the nose for poor value for money. Chobham Manor residents frankly don't see what they get from the park in exchange for this charge, given they're the only local residents who pay for it. So I know Chobham residents will be grateful for an explanation about how they might benefit from the changes that the bill makes. And I want to mention yet again the continuing limbo for many residents of East Village in Stratford. Leaseholders in East Village have lived under serious financial threat for well over 4 years now. The remediation needed to make their homes safe is still being held up because this government's previous legislation left the issue open to litigation. So how can my constituents be reassured that this bill goes further? The Secretary of State himself committed to using his planning powers to call in proposals submitted by irresponsible developers. So I have to ask, will he make good on that promise and target those who are continually refusing to act on fire safety and leaving leaseholders on the hook? A final case from West Ham. Diligent and determined leaseholders have successfully taken managing agents or freeholders to the tribunal for their dire failings. I'm sorry to tell the House that these failings were across the board, including rat infestations, lack of insulation, causing skyrocketing energy bills, no transparency in relation to the huge service charges, building safety problems, and a complete lack of accountability. Surely it shouldn't have come to this. We shouldn't be depending on individual leaseholders to battle their way through obscure systems to get their plight the attention it needs. MPs shouldn't have to make dozens of detailed representations over and over and over again. It couldn't be clearer who has the power in these disputes. And in so many cases, we're seeing leaseholders still paying the price for a system that is absolutely broken. Sadly, the legacy of years of failure to act creates understandable scepticism that change will come now. So I want to hear from the Minister today that this bill, he believes, will finally end this injustice.
Thank you very much. Andrew Rosindell.
Thank you, Mr. Deputy Speaker. Can I say it's a pleasure to follow the Honourable Lady for West Ham. We share a similar part of the world, Essex, east of London. And in Romford, just as in West Ham and the London boroughs to the east of the capital, we have all seen a huge increase in the numbers of flats and high-rise blocks built over the last 20 years. Now, Romford and Havering is a town and country borough. We don't have, or we haven't had in the past, many flats, but suddenly we're seeing a huge number of that kind of accommodation being built, and with it brings huge numbers of problems, including what we are debating today. And I thank the Minister for bringing this bill forward. I really do hope that it will deal with so many of the issues that colleagues across the House have raised today, because they're very real, and I sense there is a consensus on all sides of the House that serious action needs to be taken, because, Mr. Deputy Speaker, this can really destroy people's lives. It can ruin. They've saved to buy a property, they've got a leasehold, and yet they are fleeced by sharks, by managing agents that pile on the costs, by armies of lawyers that make their lives miserable and threaten them with losing their properties altogether. This is not right for the people we all represent, and I am dealing with this on a daily basis now in Romford. I have particular examples, and the Honourable Lady mentioned many in West Ham, but I have examples of the Stillway apartments in the centre of town in Romford. I visited them only a few weeks ago, and I saw the problems that they were facing and the failure to get responses from the managing agents, from those who are responsible, paying money for no service, being ripped off by managing agents that are simply not doing the job that they're paid to do. I went to Rubicon Court, which is actually a fairly new development, only a few years ago, and I was shocked, absolutely flabbergasted, to see how bad the people of that block are being looked after in terms of the money they're paying and the complete failure of the service provision that they're paying for. To see mould, to see rats, to see rubbish lying around, CCTV cameras that simply don't work. This is not acceptable, and I really hope the Minister will ensure that at the end of this debate and when the bill is passed into law, that it's actually going to be effective. It's no good passing legislation unless it's going to be effective and it's going to come into force very quickly. So I do have concerns about the speed that this will be enacted, and bearing in mind that people are suffering and people are living under terrible conditions and people are spending huge sums of their savings in having to deal with this, please will he assure the House when he speaks later on that there will be an effective way of implementing this very quickly? And will he also look at the points that many members have raised today about those who would actually lose their property? What a horrific prospect for someone that has saved to buy a property, they've got a leasehold, and then because of the issues we've been discussing, they are bullied and threatened that they might actually lose the property they have worked so hard to purchase. So there's so many issues here, and I really hope the Minister will take on board everything that's been said today. This is a cross-party issue. We want the best for our constituents. We want the best for those people who live in these properties and whose lives are made very difficult because of the current system. I really do hope that the laws that are being passed today, the legislation, will improve the lives of all of our constituents, and he will get my full support in anything further he can do to ensure that people in Romford and all constituents represented here today will be able to lead better lives and not wake up with that feeling that everything they've saved and looked towards having in their lives are being lost because of deficient legislation and a failure to enforce the law. Mr. Deputy Speaker, I can tell you that I've spent a lot of time in recent months visiting residents of Romford, and I visited many of these places, and I intend to go back to them and represent them, because if the one thing I have learnt about being a Member of Parliament is that we're here to serve the people we represent, and I'm very proud to serve the good people of Romford.
Yeah. Thank you very much. Janet Daby.
Mr. Deputy Speaker, and I can see there is a strong feeling and strong sense from across the chamber of concerns for our residents that are leaseholders and are caught up in very difficult situations. I would first like to speak to New Clause 67, which is in my name. I tabled this following a case that came to my attention late last year. I will then speak in support of New Clause 5 and Amendments 4, 5 and 8 tabled by the official opposition. These amendments relate to issues that have not been properly addressed by this government. This includes forfeiture, the right to vary ground rent to a peppercorn, and deferment rates. Turning to New Clause 67, my motivation for this stems from what happened to residents of Lee Court in my constituency. Lee Court is an Art Deco purpose-built mansion block dating back to the early 1930s. Many will remember the cold snap at the start of the year where temperatures went below zero and Arctic winds swept across the country. But up until mid-January, residents of Lee Court did not have any heating all winter. Furthermore, they did not have access to hot water for weeks, and prior to that, this provision was very patchy. This has seriously impacted many vulnerable residents in Lee Court. This includes the elderly, young families, people with medical conditions, and many others. Leaseholders at Leacourt repeatedly raised these issues with Driver and Norris, the block's former management agent, and Granpex, the building's freeholder, who ultimately has responsibility for the central heating system. Yet little progress was made until it came to my attention and that of national media's attention. The residents' plight included a neglected communal area, as well as a door hanging off its hinges that led to the roof, broken windows, exposed openings for rodents, weeds and plants growing through the drains, roof leakage, damp, mould and rot in the communal areas, and of course I've already mentioned the heating and the lack of hot water. Even though my constituents have now taken on the building maintenance and appointed a new management agent, this really illustrates the difficulty for leaseholders to secure recourse from freeholders who have responsible for central heating issues and other maintenance issues. As a result, my new Clause 67 seeks to open up a discussion on how to ensure this never happens again to residents. Therefore, my new clause seeks to require the Secretary of State to commission an independent evaluation on holding freeholders financially liable for the long-lasting central communal heating failures where the freeholder has responsibility for this upkeep. It is important for the government to know that I'm not asking for them to impose measures straight away, but rather I want them to pay closer attention to the problem at hand via an independent evaluation. There is clearly something wrong when vulnerable residents are left without heating for months on end, despite raising their concerns to the management agent, and the only way they seem to be heard is to go to the media. This is not acceptable. Residents' health and well-being needs were put at risk by the failure to restore Leacourt central heating. The government has a duty to look at how we can rectify this situation so that it never happens again. Can I say to the Minister if he would like to strengthen the voice of leaseholders, because leaseholders would like this. In fact, they need this. More widely, this overdue bill is welcome, but the government's planned reforms do not go far enough. And that is why I support in particular new Clause 5, which would abolish the right of forfeiture to residential long leases where the leaseholder is in breach of covenant. Now, I've heard the Minister say the government is working on this and will be looking at this issue. But I would like to add the Law Commission proposed a repeal in 2006, but there has been no action to progress some 18 years later. Additionally, Amendment 4 and 5 on deferment rates are important because during a housing and cost of living crisis with many families struggling to get by, it is important for leaseholders to acquire their freehold or extend their lease at the lowest possible cost. Lastly, Amendment 8 is important because we must ensure that all leaseholders, not just those with residential leases of 150 years or over, have the right to vary their lease to replace rent with peppercorn rent. This is because the most common forms of leases are 1999 and 125 years. Therefore, as the bill stands, leaseholders with the most common forms of lease will not be able to enjoy the right to vary their ground rent to a peppercorn. So, in conclusion, in contrast to the government's approach, a Labour government will enact the Law Commissioner's recommendations in full. Labour will make common hold the default tenure for all properties to fundamentally and comprehensively reform the leasehold system. In my constituency, the residents of Leacourt shows that the current leasehold system is not working. So I strongly suggest to the government to take my new clause as well as the Labour amendments.
Thank you very much. Wendy Morton.
Thank you, Mr Deputy Speaker. And I rise to speak to those amendments in my name, namely new clauses 13, 23 and 41. And I would like to place on record my thanks to those honourable and right honourable members who supported me with my amendments, and to the Bill Office who assisted with advice on drafting the said amendments. The piece of legislation in front of us today is important, and I think we would all agree it's a long-awaited piece of legislation. I spoke during the second reading of this bill, and I declared at that point I'm one, like probably many others, of almost 5 million leaseholders in this country. I'm also one of the many who has actually gone through that awfully stressful process of extending a lease. And what I've learned, this is prior to being an MP, but what I've learned as being an MP is that the issue of leasehold does not just affect London and our great cities. It affects constituents in places such as Aldridge-Brownhills. It affects people who bought a house on a leasehold basis and many apartment blocks that were built maybe 20 or 30 years ago. And that is why I've taken such a keen interest in this particular piece of legislation. Because I do believe that most people buy their homes. It's the biggest thing you will ever commit to in your lifetime, probably unaware of some of the complications that they may well experience later down the line. And as I raised many questions at second reading, Mr Deputy Speaker, and I also wrote to the Secretary of State. And whilst my honourable friend on the front bench has been very engaging with me, I would just like to gently say to the department a bit more engagement on matters like this with the backbenches would help enormously. That said, I am absolutely clear that I do want this bill to succeed. Though I think, like many others in this place, I still believe it could and it should go further. But I'm not going to push my amendments to the vote today for that very reason, but I do want to make a few points in relation to them. Firstly, with regards to new clause 13, which was the prohibition on new leasehold homes within 3 months, I appreciate what the Minister has said from the dispatch box this afternoon, and I do welcome that, because this was long committed from this government, and I've been seeking some clarity and confirmation of what exactly the government intends to do. So this is welcome news, what I've heard today, but I will continue to press on the point of common hold, because again, I think it absolutely does matter. And I'm keen that, moving forward, if we are to continue to look at this piece of legislation, get it through this place, this is a topic that I think we're going to have to continue to revisit to make sure that we get the best for constituents in whatever type of housing or home they live in. With regards, Mr Deputy Speaker, to new clause 23, with this amendment I was seeking a report on the disadvantage suffered by existing leaseholders. In effect, it was the sunset clause that I referred to at second reading. And the reason that I am bringing this forward was that it's very unclear to me as to the extent of the numbers and the impact of leaseholders who started the process of extending their existing lease during the period of the passage of this bill. Many will have been waiting, hoping to see where this piece of legislation would go to. And quite feasibly, it will include people who have been almost forced to extend their lease in order to sell their home, because with a short lease, as we know, it's very difficult, if not impossible, to get a mortgage. And I'm pretty certain there will be leaseholders who I know wouldn't be able to wait and see the outcome of this bill reaching royal assent. And I do believe such leaseholders risk being seriously disadvantaged. So my amendment seeks to take steps to assess and then remedy any unfairness by considering issues such as marriage value, legal costs, and charges that this particular group, however, it may be a small group, but I don't think we really fully appreciate the size of this group, compared with those who go down the leasehold extension route after royal assent. And in a similar vein, Mr Deputy Speaker, my third amendment, which was new clause 43, seeks to redress what I see as an imbalance and an unfairness again of marriage value and those leaseholders who extended their leases many years ago or prior to this bill passing through this place. And by seeking to simply produce a report, what I'm hoping is that we can better understand the extent of some of the challenges around this particular, not just piece of legislation, but system that we've heard today is so feudal and so difficult to navigate and has disadvantaged many, many leaseholders over the years. I think it really is important that we do not lose sight of the need to address the issue of marriage value. And the fourth area, whilst I did not put down amendment I just will touch on again, and that is the issue of ground rent. Many other colleagues on both sides of the House have mentioned this, and I'm sure that the Minister was clear in his response to me, but I think we really need to continue to push forward for those changes as well. So I will be supporting this bill tonight. I do welcome the steps that have been taken, but it's absolutely clear to me the many examples that colleagues on both sides of the chamber have highlighted today. I'm pretty certain the examples that we've all seen in our inboxes from our constituents, particularly around the challenges of service charge. These are things that I think we need to continue to go further on, and I, for one, will continue to gently nudge the Minister. He's nodding his head because I know he does a really good job, and I'm pretty certain he gets this issue. But let's continue to work together for the benefit of our constituents. Thank you.
Yeah.
So I've got 9 members trying to catch my eye. So if people do about the 5-ish minute mark, that would really allow everybody to get in roughly equally. There's been some slippage, I can see that. But Stephen Timms.
Thank you very much, Mr Deputy Speaker. I rise specifically to speak to the new clause in my name, clause 24. It was considered at committee. I'm most grateful to my honourable friend, the member for Brent North, who moved it in committee, and I'm grateful to the Minister as well for his response to the clause, and I'm grateful to the honourable members for Loughborough and for West Suffolk, who've added their names to the clause on the order paper. I'm grateful to the Minister for his reply in committee, but I think his reply missed the crucial central point in the amendment. At the moment, the risks of exposure to asbestos in a workplace are managed by the Control of Asbestos Regulations 2012, which is monitored by the Health and Safety Executive. For every workplace under those regulations, there is a duty holder responsible for monitoring the condition of the asbestos. They are required to keep up-to-date records of the location and condition of all asbestos-containing materials, to provide that information to anybody liable to disturb the materials, and to develop a plan for managing any risks which arise. Now, residential blocks with a commercial freeholder will generally also have a duty holder because the block will have been for them a workplace. So it's covered by the Control of Asbestos regulations. It's usually the freeholder or their agent who is the duty holder. And that duty holder is responsible for all the common areas in the block, such as foyers and staircases. Now, the effectiveness of this whole regime is debatable. The 6th report in the 2021-22 session of the Work and Pensions Select Committee expressed considerable reservations. It is doubtful, I think, that the Health and Safety Executive is doing enough to monitor compliance, and the assumption that leaving asbestos in place is better than removing it is increasingly questionable as the asbestos ages. But there is at least a clear regime for managing the risks. The concern that motivates this new clause is that following a transfer of the kind made possible and facilitated by the bill, there will no longer be a duty holder for the communal areas in that block. At the moment there is, but the responsibility will be entirely extinguished, as far as I understand it, on transfer. The asbestos is still going to be there, the risks will remain, but nobody will any longer be responsible for managing them. No individual resident, understandably, will take on the responsibility, but there'll be no corporate entity to do it either. And in fact, it may be worse than that. The residents may well not be aware before the transfer is completed that they are taking on both a financial liability for managing the asbestos in the communal areas and possibly a risk to life as well. And I think it's important to bear in mind that we are seeing 5,000 deaths per year at the moment as a result of past exposure to asbestos. So the Minister said in his response in committee that the amendment, quote, would duplicate the existing duty in Regulation 4 of the Control of Asbestos Regulations 2012 for landlords to survey the common areas of their property. But the newly enfranchised property would not fall any longer under Regulation 4. There'll be no landlord to survey the common areas once the transfer has taken place. So new clause 24 aims to prevent this problem occurring. It requires landlords to perform a detailed survey of the asbestos present in the building within 3 months of a transfer taking place, and then requires the landlord to remove any asbestos which is there. There is at the moment a 150% tax relief for businesses removing asbestos from premises, so delivering removal will not be costly for the landlords. It will save newly enfranchised leaseholders from a large and probably unexpected liability and from a potentially lethal long-term risk as well. So I hope, Mr Deputy Speaker, that makes the case for this change clear. Let me finally make this point. I'm very grateful to the Minister for his assistance with the residents of Barrier Point in my constituency, and I think we now have a meeting in his office coming up next month. Last night I had a Zoom call with, a regular Zoom call with leaseholders from Waterside Park in my constituency. Before Christmas we thought we had a clear way forward. Barrett's, the builders, have signed up. Aviva, the current freeholder, was happy. Last night on the Zoom call we learnt that the requirement of the building safety regulator to look at any proposals for a minimum 8-week period is going to very substantially delay the work which has been committed. And I do wonder whether the Minister can look at that and whether really it is necessary to insert another 8 weeks wait for residents who've been waiting so long for these problems to be resolved.
Nickie Aiken.
Deputy Speaker, I fully support the Government's wish to overhaul the antiquated and feudal system that is the leasehold system in this country and address the imbalance of power between freeholders and leaseholders. And I want to take this opportunity to thank the Minister for his ongoing discussions with me on a number of issues I have with the bill and for attending the leasehold roundtable I held with my constituents recently. Now, I would like the Government to abolish the system completely, but I understand that that's not going to happen in this bill. But I have tabled 4 amendments which I do believe will improve the bill even further. First, new clause 12, which reduces the participation threshold required to claim right to manage to 35% from the current 50%. This is a massive issue in the cities of London and Westminster. Over 1,300 properties in the City of London and an eye-watering 12,100 in Westminster have owners living abroad or are owned by companies using central London's golden postcodes as a place to park their cash. This reduces the ability of leaseholders in these blocks to secure the 50% of signatures required to achieve right to manage, as it is incredibly difficult to contact these overseas leaseholders for a meaningful discussion. Allow me to give you an example of this type of dilemma in my constituency. Residents in the quadrangle in the Hyde Park estate say leaseholders in their block will struggle to meet the 50% participation threshold. They estimate that at least 40% of their block leaseholders do not live in the building and are uncontactable. Lowering the threshold to 35% in this new clause 12 would allow far more leaseholders living in similar blocks the chance to manage their own buildings. Mr Deputy Speaker, I must commend this bill for its work to support blocks which have shared commercial and residential usage. The bill proposes to increase the proportion of commercial or non-residential space permitted in an individual block for a right to manage application from 25 to 50%. However, I believe we can go even further. I have heard from many residents whose blocks will fail to qualify even with the threshold rising to 50%. For example, residents at 8 Artillery Row in Victoria believe that increasing the threshold to 50% does not go far enough as the residential element of their block is lower than 50%. That is why my amendment, new clause 17, is needed, as it would allow residents in a block with up to 75% commercial premises to allow for the right to manage. Mr Deputy Speaker, my new clause 14 again is designed to allow more leaseholders to strive for the right to manage, especially those in mixed-use buildings. Simply sharing a broom cupboard with a commercial property can disqualify their ability to claim the right to manage. For example, Cambridge Court in Marylebone, where leaseholders would benefit from the government's proposals to increase the threshold of non-residential thresholds allowed in a building when striving to manage their blocks. However, they are concerned that their ability to qualify for right to manage would be undermined by the existence of a single shared car parking space in their building. My new clause 14 it's an amendment to the Common Hold and Leasehold Reform Act of 2002 and adopts the Law Commission's recommendation 5 in its right to manage report, allowing leaseholders in mixed-use buildings with shared services or underground car parks to exercise the right to manage. And finally, Mr Deputy Speaker, I come to new clause 15 tabled in my name. This amendment is to correct the unintended consequences of the Building Safety Act 2022. This is because the Act has interfered with the long-standing Section 24 regime, which was a vital right for leaseholders. The Building Safety Act introduced an accountable person mechanism that expressly banned Section 24 managers from being the accountable person. And consequently, specially trained, vetted and professional property managers willing to take on difficult sites have been barred from being the accountable person. This makes absolutely no sense and stripped leaseholders of an existing right. They surely cannot have been, this surely could not have been the intention that the government planned when it tabled the Building Safety Act, which was intended to provide leaseholders with additional statutory protections. There are so many leaseholders, not only in my constituency but across the country, who would benefit from applying for a Section 24 manager, but they cannot risk it if they are in blocks 18 metres or higher because of this issue with the Building Safety Act and the accountable person regime. It is imperative that our buildings are safe, that leaseholders are safe, and that the burden does not fall heavily upon these leaseholders. Mr Deputy Speaker, I won't push my amendments for a vote tonight, but I do hope the government will consider what I have spoken about today and will work with me to see what we can do to introduce them perhaps in the other place. This is a watershed moment for the government to prove it understands the terrible treatment leaseholders have faced and continue to face from incompetent freeholders, and that we are addressing the imbalance between freeholder and leaseholder, and I hope this bill will deliver real change.
Thank you very much. Helen. Thank you very much, Mr Deputy Speaker. I rise to speak to new clause 1, tabled in my name, and in support of a number of other new clauses and amendments tabled by honourable and right honourable members from both sides of the House. I tabled new clause 1 because, as the honourable member for Harborough, who's no longer in his place, has already described, fleasehold is a scam. And new clause 1 attempts to deal with this issue where a freeholder is trapped in a situation where they're paying for estate management charges for the areas around their development. So that might be roads, play areas, open spaces. And new clause 1 critically also deals with the shared assets that might be in use to service their homes. So, for example, ground source heat pumps, septic tanks or sewage pumps. Now, there are, I'm sure, many instances where a management company does a great job and charges reasonable fees for its work. But my inbox, and I know the inboxes of other honourable members, have horrifying examples of the management company, usually directly owned by or related to the developer in North Shropshire, either failing to do a good job or indeed do any sort of job altogether. So, for example, there's a freeholder in my constituency who must obtain an information pack from the management estate company to sell their house. And despite repeated requests, the constituent hasn't received an information pack. so their sale is significantly delayed and it's at risk of falling through altogether. The management company is just apparently a shell. They don't respond to correspondence, they don't hold an annual general meeting, they don't provide accounts. So the residents who are affected by this are currently powerless to take control of this company and appoint a reliable professional to provide the services that they so desperately need. And new clause 1 would allow them, where the management company has gone AWOL and will not respond to anything that they request of them, just to take control of that company and do it themselves. And it also extends to assets. Now, I think assets might be more of a rural problem than an urban one when it comes to shared estate charges. But I've got an example where a developer installed a ground source heat pump to provide all of the heating and hot water for a barn conversion development, which involves several houses in the same set of barns. Now, this developer has two separate companies. One is the management company, in which he charges the owners of the houses for their electricity bill. And in another totally separate company that was nothing to do with the sale process, he placed the heat pump. And so he's able to cream off all the RHI income for himself. So he provides accounts to residents for the management company, but he doesn't provide them with any information about the fundamental asset that's servicing their home. And so they're unable to benefit from the renewable heat incentive that accrues in relation to it, and they don't know whether it's being properly maintained and serviced, and they are unable to do so and have no rights in relation to that heat pump. Now, that's quite a complex situation where I suspect there may well be fraud involved as well. But there are other examples where residents are unable to get their street lights fixed, potholes sorted out, drainage is a huge problem, and they can't get a response in any way from the management company responsible. So new clause 1 would allow them to take over their estate management companies in these instances, and it would hopefully provide a significant disincentive to management companies in the future from failing to provide the services that they are presumably making quite a lot of money out of. But crucially, it would enable those trapped in existing arrangements to exit them. I think other members have mentioned it. Once people have bought a home and they have a full-time job, they don't have time to endlessly chase up their management company and take them to court and tribunals over the services that they failed to provide. One of the residents I've been dealing with said, I just don't have the time to deal with this. I'm a full-time truck driver. So the idea of new clause 1 is that it makes it easier for those people to take control of those companies and take control of over their own lives. Now, Mr Deputy Speaker, as has already been pointed out, it's very worrying that these arrangements have been allowed to proliferate across the country. There are many, many residents now paying both council tax and service charges for street lighting, grass cutting and drain clearing that would normally be provided by a local authority. Those people are literally paying more for the same service, and it's indefensible. And there are millions of people trapped in these arrangements. Now, Amendment 18, tabled by the Honourable Member for North East Bedfordshire, I think attempts to address this issue by preventing such charges being part of the estate management charge, and that would certainly provide a disincentive to developers to use this model in the first place. But beyond the scope of this bill, but something I would really urge the government to take forward, is to prevent these awful arrangements from happening in the first place. It's much better for a road to be adopted and maintained by the local authority so that everybody's paying for the same services on the same level playing field. And for those people who are using it, who have a shared asset, who are trapped by an estate management company, if their developer has failed to pay a Section 106 in the first place, they're also on the hook for that money. I've got residents who have a charge over their shared area for £30,000 for a Section 106 that wasn't paid. I've got other residents paying £1 million between 14 of them to bring a sewage pump up to standard because it's an environmental health hazard. And if those had not been allowed to occur in the first place, if the local authority had had to require a financial bond to be placed so that when that development was finished, it wasn't up to scratch, the local authority had the money to make it up to scratch and adopt it, they wouldn't be in that awful situation. And I would really encourage the government to take that away and think about how we can make that protection for people in the future. I will.
On the estate management charges, can I draw to her attention, as the Minister, the article by Patrick Hoskins in the Times today about estate management companies and estate management charges, and hope that the government will actually look to see what he's written and see what they can do to make things better.
Thank you very much for his intervention. And on that point, I'm going to conclude, Mr Deputy Speaker. I'm also in support of the amendments which would require professionalisation of the industry. I think that would be very sensible and consistent with other legislation that the House has passed, and also supportive of new clause 5 and amendments 4 and 8 tabled by the Shadow Bunch, new clause 39 tabled by the Chair of the Select Committee, and new clause 25 tabled by the Father of the House. So in conclusion, this bill goes some way to provide the protection that we need, but I think it needs to go much further to protect freeholders from rogue developers and estate management companies, and I would really urge the government to take that away and do more.
Thank you very much. Now, to protect the last 6 speakers and to protect the ministerial time as well, there's a 5-minute limit on all the speeches, and that will give sufficient time for the front bench to respond. Rachel McLean.
Thank you very much, Mr Deputy Speaker. It was a great pleasure to serve in the Bill Committee for this bill. We had a great debate. There was actually a lot of agreement across the chamber. These are deeply conservative reforms, Mr Deputy Speaker, championed by none other than Mrs Thatcher, starting in 1965, and she continued to do so throughout opposition and also in her premiership. And I would just gently say to anyone listening, or the opposition of whatever party, they mustn't fall into the trap of making this into a political football. They must engage with the seriousness and complexity of these reforms, in part because, as we've heard, they actually did very little to advance these very significant reforms during their own time in office, and I suspect that they backed away from it because of the very significant legal challenges that they would have faced, as we ourselves will face, no doubt. Just pretending they don't exist is not a serious position. But I would say to the Minister and to the Secretary of State, who are aware of my comments, we must not buckle and we must continue to take this forward. So it is great to see the package of amendments laid by the government, particularly on new clause 42, which is the ban on leasehold houses. I would like the Minister to think carefully about how he will address the inevitable imbalance and creation of a two-tier system where some people will have the freehold of their houses, but some will not. And an additional imbalance also between flats in our urban areas and in our leasehold, new freehold houses, a point very well made by James Vitale in a policy exchange report. And I am slightly worried about the omission of the retirement properties from this, so perhaps the Minister could return to that. In committee, I spoke about the need to really, truly move towards a common hold system. I think the opposition's new clause 11 is something of that nature, and I very much hope that as the bill goes through, completing its stages, that the government, maybe here or any other place, can look at that suggestion, because I think we do need to set out the future legislative scaffolding for our 5th term in office, to build on all the work that we've done, so we can finally get rid of this leasehold system. Other members have actually mentioned a lot of the points I've made about the shared services. I know that my honourable friend from Westminster North has raised that. That was also one of my concerns, and my honourable friend from Harborough has done a fantastic job talking about the lack of adoption by local authorities, which new clauses 7, 1 and 2, I know the opposition clauses again. This problem isn't going to go away. It's also a blight on many homeowners in Redditch, and it also goes to the heart of our planning system, and we really do need to look at that. We cannot pretend that that's going to solve itself. I want to thank the Minister for writing to me about one of my concerns about litigation costs. That was clause, I think, new clause 3 looks at that. He's reassured me that what's in this bill will go the distance to ensuring that leaseholders are not subject to unjust litigation costs from their landlord. And that is one of the cases highlighted by Liam Spender and many others. Hugely complex issues, but we must tackle them. I want to see ground rent being reduced to a peppercorn. It is pure extortion. It is a feudal relic from medieval times when people were serfs and worked the land. We should not have this in 2024 in any year at all. I refuse to believe that there is not a way through the wit of man and the considerable intelligence of the ministers on the front bench to solve the issue where there may be some financial assets that are held in pension funds. I just don't buy this incredibly con artist, this Mr. Steve Wybrow and his outfit, who's pretending to be a pensioner and pretending that somehow we are robbing pensioners. I would urge anybody with an interest in this debate to look at the genuine pensioners who are fighting for the rights to have pure enjoyment of their own properties, which they richly deserve after a lifetime of working. Forfeiture, I will make my final remarks on forfeiture. It must go. Forfeiture of a long lease cannot be right. It cannot be right that a freeholder can hold this nuclear bomb over somebody like Dennis Jackson, a pensioner of Plantation Wharf. He disputed a £6,000 service charge. That led to £80,000 legal bill. He had his £800,000 flat forfeited in a 10-minute hearing at Wandsworth Court. I want to thank all the work that Lease have done to help him. That just simply cannot be right. We must address this. And I want to see us now finally finishing the job that Mrs. Thatcher started when she was opposition housing spokesman in 1965. We must finish that job, and I thank the Minister for all the work that he's done so far.
Stella Creasy.
Thank you, Mr. Deputy Speaker. I really feel for the Minister today because he must be just kicking himself, because it's probably one of the few debates I've heard recently in this place where I haven't heard a bad idea. Because as constituency MPs, we see time and time again the problems caused by retaining this feudal system of leasehold. And I suspect the Minister, who I know has been looking at this for some time, is kicking himself because what he'd really like to do is just abolish the whole thing. And actually what you've heard today is support from across the House to do just that. So in the short time available to me, let me say again to him that he would have our support to just move to common hold. He himself talked about how common hold probably was the better model either. For those of us living in the vortex of gentrification, where thousands of flats have been built in our community, this is an incredibly pressing issue because we know the casework that we have seen over the last few years is going to extrapolate as a result of leasehold continuing on. That is why I wish to see the government change its mind perhaps in the other place in getting rid of leasehold altogether, and also why I've been pressing my own local authority to listen to the concerns of local residents stuck with leasehold and change our local plan to make common hold the default. And I hope that they've heard the debate today and will rethink their opposition to this. I want expressly to show my support to the amendments in the names of my front bench colleagues, but also draw the Minister's attention to two amendments that I have tabled, which are on issues to do with the existing system and the problems that leaseholders have faced. With 12,000 leasehold families in Walthamstow now, I know these issues will come up time and time again. New Clause 2 is about the fact that although we have leasehold legislation, it doesn't tally with our consumer legislation. So leaseholders pay a service charge. They have a contract with freehold management companies to oversee the problems in their properties, but few residents feel empowered to be able to actually access those rights that exist under the Consumer Rights Act to have a reasonable service within a reasonable time frame for repairs. Today, colleagues across the House have given countless examples of that. Let me add my own, which is where this legislation proposal has come from. And I'm sorry that the member from Lewisham East is not here, because when she talks about Lee Court and her new clause 67, well, my residents in Walthamstow, in Essex Brewery, have been without hot water and heating since before Christmas and are still without hot water and heating, with little sight of any change. Essex Brewery was built just 5 years ago. Yep. It's now become apparent that the build by Crest Nicholson was poor at best and downright a con at worst. Crest, until January this year, was actually on the management committee. They made over £100 million in profit in the year that it was built. They've made half that this year, and possibly less, because of widespread concerns about the conditions of the builds that they've made. Yeah. What do you do when you've bought possibly your first home, whether through shared ownership or leasehold, as hundreds did in this development, and find that the pipes are faulty that bring the hot water? I'm sorry to say that those residents have little redress because the management company brought in Kinley, Folkyard and Hayward, another multi-million-pound organisation, left them without any explanation about why they weren't going to repair their hot water bottles before Christmas until after Christmas. What a Christmas present that was. Grinch had strong competition. That was another layer of bureaucracy. KFH were appointed by the Essexbury Management Company that was established by the freeholder Helpfader to meet those obligations. But KFH told the residents, because their insurance policy said as long as they had water at all, it was habitable, they weren't going to do anything about it. That's left hundreds of residents, many of whom vulnerable, for months on end without any hot water or heating in the current weather. Residents who've had to boil kettles to try and get some hot water to cleanse their babies, or paid bills they cannot afford for extra heating through portable heaters. Now, for those who've got shared ownership, it's even more complicated. Metropolitan Thames Valley Housing, who say that they own 24 of those properties and are prohibited by law from fixing the problem. My amendment, New Clause 2, is about matching consumer legislation with leasehold legislation and giving those residents the right of redress. Not saying, well, you've either got to buy out the leaseholders if you want some up the property control, or you're stuck with them and waiting to see. And I hope KFH here today and are ashamed of their behaviour. Can I also draw to the attention of the Minister Amendment 1, which is about leasehold tribunals? Now, I know he says that there is precedent setting. Residents across the country would tell him otherwise. I beg him to look at the Warner properties in Walthamstow, Y&Y Management, who repeatedly rip off constituents across the country. The member from Harborough isn't here asking why people have to pay terrorism insurance. In Walthamstow, that was the Warner estate company who said because the plane bomber lived in our constituency, 3,000 households had to buy terrorism insurance. These cases come up time and time again. In leasehold, they don't get fixed in the tribunal. Amendment 1 would give precedent.
My Chelmsford constituents, these bills simply cannot come soon enough. One constituent told me how he bought his leasehold flat 7 years ago, but now he and his wife want to move to a bigger home, start a family and progress their lives. For the past 3 years, they've been unable to sell their flat. They've tried listing the property with many different estate agents and had many offers. But no buyer is able to get a mortgage on the property due to a clause in the lease which means that the ground rent can be doubled every 15 years. According to this constituent, nobody in this block of 20 flats has been able to sell a property since 2018. They feel stuck. Another constituent in another block of flats says that she and her family of 3 and a dog have been trying to move out of their one-bedroom flat for over 2 years. Because the ground rent exceeds the £250 arbitrary threshold set for properties outside of London, buyers cannot get a mortgage. Because if the leaseholder was to default on the ground rent, the landlord would have the right to repossess. And this family have tried deeds of variation, indemnity policies, multiple mortgage lenders, all to no avail. Mortgage companies literally value the flat at £0. For most people, buying one's own home is meant to give security and stability, choice and freedom, but for these leaseholders, life is more like being locked in a time warp. They're trapped in a prison of their own property, unable to move on. And so I do welcome the measures on this bill and the amendments that the government's tabled today. I've listened carefully to what my honourable friend, the member for Walsall, and others have said about forfeiture and about what the Minister said on caps on ground rent. The Minister does need to go further on this issue. Another group of leaseholders who are really struggling are those living in King's Tower. It's a 12-storey building with a small amount of combustible installation on the spandrel panels on the outside of the building. It may need remedial work to remove and replace these. I think it's shocking that 7 years after Grenfell Tower, that huge company Barrett's and the property management company Estates Management Limited have still not carried out this remediation work. One of the leaseholders, Richard, emailed me today. He said back in 2009 the service charge was just £800 a year. This year he thinks he's going to have to pay £4,000. Richard and other leaseholders was first told of the potential issue in August 2020. He says that since then they've been unable to fulfil any form of normal life due to these additional fire safety issues and the costs. He says, I genuinely feel ill to think of what our service charge demand is going to be in March this year. So, as well as increases in insurance, Barrett's and E&M are blaming the increase on the costs needed to register the building under the new regulations of the Building Safety Act, which we introduced in 2022. I'd like to thank the Minister for his letter to me on this subject. But even though paragraph 9 of Section 8 was meant to protect leaseholders from the costs of legal and other professional services, it is clear
that my constituents and many others feel that they are being gouged for excessive costs. Finally, some freeholders also face issues. There are some truly stunning residential developments in Chelmsford where the parks and public areas are beautifully maintained by estate management companies, but this is not universal. I note that Freeport was named by my neighbour, the Right Honourable Member for Whittam, as a company that is particularly difficult to deal with, even for a Member of Parliament, and I agree with her. It's so very hard for freeholders to hold management companies to account and to make sure that the maintenance is done well and that the costs that they are charged are reasonable. So I am very glad that this bill will also include measures to give freeholders access to support via redress schemes and require estate management companies to be transparent. And when more leaseholders become freeholders, as I truly hope they will, thanks to the changes that are brought in this bill, we need to make sure that that these terrible practices are not just passed on to freeholders, but that freeholders also have these rights and ability for redress.
Mr Deputy Speaker. The amendments tabled by the Government, new clauses 30, 31 and 32 in particular, I think will certainly offer my constituents some hope and a quicker means of redress to many of the discussions and points that have been raised today in the House. I would just like to press the Minister with regards to some of the concerns that my constituents have raised, and if I'm very candid, I think all colleagues today have raised them. And this, of course, are constituents who are leaseholders, and this whole issue of remediation of defects and, quite frankly, transparency and accountability. I have one development in my constituency. It opened in 2019. That's now a significant period of time, 5 years, and residents have just a shocking case of misery and distress in terms of what they're experiencing. Problems including water ingresses, damp, mould, children getting sick, which I think is completely unforgivable because of this, damaged sprinkler systems, defective and non-compliant fire doors, that's just unthinkable in this day and age, inadequate insulation, we've already heard about water pipes and the lack of heating and cold water, roofing issues, damaged gates and the poor maintenance of grounds. And on top of that, guess what happens? You raise a complaint, nobody does anything about it. But I tell you what does happen, when a letter comes to constituents, they basically have various service fees that are increased all the time, and that is just not acceptable. Seeking redress is just not happening. And so not only are they frustrated, but what we see here is a clear issue of buck passing. And that to me is just shameful, and we have to redress that. Even so, in light of this, there are reports of residents just in this particular property, which by the way was a permitted development, and I think we should just really pause for thought here about permitted developments, which I'm very pro. I think we need more of them, but we have to make sure that charlatans do not come along and just exploit people who are desperate to buy their own home. This is their first property, and then all sorts of things are happening within the building. But I have had reports from residents who have purchased their property more recently, and guess what? They weren't informed of all the defects and the problems going on. And I think this is simply scandalous, I really do. I do just want to mention again First Port, because I think this is a topic of wider debate, quite frankly, in this House, and how management companies such as First Point, and I'm meeting with them at the weekend, you know, again, why is it that they feel that they are let off the hook? You know, they won't effectively engage properly. And in one case, the leaseholders of a site in Stanway were not informed or notified of the change in management company for about half a year. Now, this is just, you know, every single colleague in this House has cases of this nature. First Port have refused requests to hold AGMs, and they've just been lacking in their visibility. And actually, if I may, I'm going to praise my county council, Lydia, who's a member, divisional member for the area in question, County Councillor Kevin Bentley, who has secured a public meeting this weekend. You know, this is the first point of redress that we will have to actually get in the room with these people. But quite frankly, contractors, you know, come in, people are charged for works and monitoring works that never take place. This goes on and on and on. So I hope the Minister
can give some reassurance, and I'm really grateful to him for the way in which he opened the debate and spoke quite frankly about the issues and concerns. I would just like to put one point as a suggestion really to him. It was announced yesterday that the CMA, the Competition and Markets Authority, are looking into the practice of house builders and whether or not there's been collusion around pricing, development of schemes. Can I suggest this might be worth actually looking into management companies, because many of those house builders also come part and parcel. They're the ones that do the negotiations with these management companies. There is a lack of transparency here. Should we be looking at more open book contracting around management companies, publications, of how they are brought on board by the developers, so that we can have greater transparency for the purchasers? And I think that is one of the really important areas. He may wish to ask the CMA to look into this as well, because his department has already enlisted the CMA. I hope that he'll be able to respond to some of these points when he sums up. But I think all members today are just grateful to raise these points, and it speaks to the totality of what we're seeing as a sense of lack of fairness for many of our constituents, which clearly this government are pressing in the right direction and looking to redress.
David Simmons.
Thank you, Mr. Deputy Speaker. I very much welcome this bill, which addresses the frustrations expressed by a great many leaseholders in my constituency. And I'd like to place on the record my thanks in particular to Susie Killett of the Pembroke Park Residents Association and Joe Tapper of the Cygers, both of whom have faced significant challenges representing their communities in taking forward issues that arise out of the management and the lack of services often provided to them under the lease arrangements which they have. But I'd particularly like to place on the record my thanks to ministers for the fact that this is legislation which takes into account the way that the market has changed. And many, many years ago, I started out my career as a financial advisor, dealing with people who were taking out mortgages. And one of the things which very starkly has changed is the extent to which leaseholds are seen as an opportunity to extract money from people as investments to be traded by freeholders on the basis of extracting the maximum possible amount, rather than on the basis of ensuring that a good quality of service is provided. And there are examples that I was involved in as a local authority councillor where part of the planning agreement was that the arrangements for roads, parks and open spaces would be brought up to an appropriate standard to be adopted by the local authority, and the development having been completed, an opportunity was spotted by the developer, and therefore people who'd moved in on the understanding that the local authority would be taking over because the roads, for example, were built to adoptable standard, then found that that did not happen because it was seen as an investment opportunity, very much in line with the rip-offs that we've seen referred to by members across the House. May I commend ministers on taking a balanced approach in respect of the need to recognise that there is a link between the arrangements that this concerns and our housing supply. We know that the UK has the oldest housing stock in Europe, and the ability of freeholders of larger developments to regenerate sites where properties, for example, that have been rented are falling vacant over a period of time could be inhibited if we ensure that there is a proliferation of small freeholds on those types of sites. And we know that if we are to ensure that the quality of our housing, in particular its energy efficiency, is brought up to a good standard, we need to make sure that it is still possible for larger sites to be regenerated and that we don't inhibit that completely whilst addressing a different concern about the rights and the freedoms of leaseholders. Now, I made mention, Mr Deputy Speaker, of some constituents. I know the situation that's faced in particular at Pembroke Park is a really good example of why the reforms in this legislation are so important. A development constructed on a former military site by Taylor Wimpey, then handed over to management by A2 Dominion Housing Association with a mix of social housing tenants and private leaseholders. There are umpteen issues still more than a decade after the completion of that site, and simply getting A2 Dominion to respond to problems, insulation that was never installed in buildings to the building regs standard, a complete failure to ensure that proper ventilation was installed in the buildings, drains that are completely inadequate. And whilst there's been progress, I think I would add to the places raised by other members the issues of A2 Dominion. I commend their relatively new Chief Exec, Ian Wardle, for the progress that he is making. But it remains a huge challenge to my constituents and a source of frustration that as opaque charges rise and rise and rise, the actions of that organisation make it incredibly difficult even to understand sometimes whether the basic legal protections that they enjoy under existing legislation are being observed. For example, in the way that insurance costs are apportioned across a very large property portfolio. Mr Deputy Speaker, I'd like to just conclude by saying how strongly I'd like to support the points that have been made around forfeiture provisions. Now, I've seen a number of constituents who've come to me with significant challenges, justifiable concerns about the level of things like service charges that have arisen in their properties. And it is completely unacceptable that they would face a situation where they forfeit a significant amount of value which they have paid for, they have earned, and which potentially falls to a developer. That is, again, an opportunity for those who are shamelessly greedy to rip off our constituents. And I'm very glad that this legislation and the comments made by members across the House today will take a significant step forward to ending that practice.
Richard Fuller.
Thousands of homeowners in my constituency and millions across the country who face estate management charges will have their rights substantially increased thanks to the provisions in this bill. And I'm extremely grateful to the Prime Minister, to the Secretary of State, to the Minister on the bench today, and to his predecessor, the Honourable Member for Redruth, for absolutely focusing on including estate management charges in this bill. And it is extraordinarily timely, given the findings released this week by the Competition and Markets Authority. And let me just quote a couple of parts from their final report. They write, as a result of the emergence of the private management model and the market power conferred on some management companies, households are facing financial and emotional detriment. And if the status quo is maintained, this is likely to worsen over time. And they propose that governments, both the United Kingdom and the devolved authorities, look at two areas of measures. First of all, to provide greater protection to households living under private management arrangements, and that's what this bill is seeking to do. And I know the Minister has potentially some cards up his sleeve on forfeiture, on right to manage, probably on a host of other things. I hope that he will shake some of those cards loose as this moves up to the upper house. But secondly, the Competition and Market Authority says to prevent the proliferation of private management arrangements for new housing estates. And to do that, it says two recommendations. Number one, implement common adoptable standards for public amenities on new housing estates. And number two, implement mandatory adoption of public amenities on new housing estates. That sounds good. That sounds like a long time away. We know this is growing rapidly, and so my Amendment 18 seeks to stop it in its tracks by saying that you may not pass on to homeowners charges for any service or provision that is usually the recourse of your local authority. And I cannot understand for the life of me, if I just may say, why the opposition aren't supporting this particular amendment. Now, I know it's a bit of a club on this. It's not very nuanced, but it gets to the heart of the matter. And so I'm looking for the Minister today, if he can just give some reassurance, I think to the opposition, as well as to me and to backbenchers, that he will look at what he can do in this bill to make progress on some of the measures mentioned by the Competition and Market Authorities. I know he wants to. I'm just hoping he can go as far as he can. May I just now turn to the provisions in the bill that relate to marriage value and the treatment of marriage value as proposed. Now, there is a concern, there's been stressed a number of times, that we are making decisions in this bill with some limited information on some important economic effects. For example, the decision of the Secretary of State regarding the options for the future of ground rents arising from the recent consultation. 2, how the government might determine the appropriate rates for the deferment and capitalisation rates, a range of unquantified effects in the bill's impact assessment. In committee, I tried to learn a bit more about whether marriage value is a real thing. It is a real thing. It's been enshrined in legislation in 2002 and previous to that in 1993. Now, the bill is not actually abolishing marriage value, it's transferring it. In fact, you can't abolish marriage value. In maths, it is an optional value. It has real value. So this is not a decision to abolish something. It's a decision to take it from one group of stakeholders and give it to another group of stakeholders. It is a £7 billion transfer of wealth from one group to another. And under the provisions of the bill, it would be retrospective on contracts always entered into. Now, that is a perfectly legitimate public policy position if we wish to take it, but I would just say to the Minister, it is fraught with legal risk and legal jeopardy as it is currently proposed. The amendments that I put down would seek to provide a safer passage for this bill as it goes through to become law. It would ensure that any lease that is below 80 years at the time the Act is passed will continue to have marriage value, but any lease that goes below 80 years after the Act is passed would not have marriage value. And I just ask the Minister to consider that as he moves to the next stage of this bill.
I leave the House, Minister, to wind up the debate. Lee Rowley.
Thank you, Mr Deputy Speaker. And I want to start by thanking all members for their contributions to the debate this afternoon. And I think it demonstrates, given the breadth of discussion across the House and the general consensus about needing to do things, we can debate and discuss precisely how far we go, but I think it is a general consensus that progress needs to be made here, and I know that this bill, and I think everybody in this House would accept that progress has been made and is being made. I'll turn, if I may, to some of the points which Honourable and Right Honourable Members made before just summarising shortly before 6 p.m. The position before we move on. I want to turn first to my humble friend from Worthing West, who has new clause 25 has put down. He is absolutely right. It is an important issue. As he indicates, a consultation is open. We will be reviewing the responses to that consultation very seriously, and I would encourage anybody who has such strong views as my humble friend has outlined to make sure that they contribute to that so that we can think through that in the round. The Honourable Gentleman from Sheffield South East introduces new clauses 39 and new clauses 40 and spoke passionately about both of them. And I do understand the point that he is making on both of them. I hope that some of the changes that are within this bill should mean that the acquisition of the freehold is much easier. There is a disincentivization for freeholders, as the ones we talk about on a very regular basis, to not respond or to go slow, which should mean that the right for first refusal falls away to the extent that it is no longer necessary. My right honourable friend, from Camborne and Redruth, I'm very sorry to hear about the issues that his constituents are experiencing. He's been very kind to be able to articulate those to me already, and I'm keen to continue talking, and I'll be very happy to meet him as he requests, because I recognise about the specific matter is an important one for his constituents, and we need to look into it in more detail. The honourable gentleman from Brent North, who served on the Bill Committee, raises many useful points in this area. I can't do justice to all of them, but in particular on the concern he has about Dejan and building safety, I would be happy to continue the discussion to make sure that if there is an issue that we haven't worked through on this side, that we ensure that we understand that in more detail. My honourable members from West Ham, my honourable friend from Romford, my right honourable friend from Chelmsford, and my honourable friend from Risley, Northwood and Pinner, all highlighted the importance of making progress on this, all highlighted the huge iniquity that is causing individual people and individual blocks in their areas. And it is exactly the reason why we have to make progress, and why I hope that this bill is a good proposition for doing so. The honourable lady from Lewisham East, who has been so kind as to give me more detail about that in a separate discussion. It is absolutely unacceptable, some of the things that I've heard both from the honourable lady and from the honourable lady from Walthamstow, who is not in her place, who has a similar issue. And I absolutely appreciate the individual concerns that are there, and I'm keen to continue the discussion that we are having so that we can learn from it for the broader good of building safety sector in general. My right honourable friend from Aldridge-Brownhills had put down some very important amendment, which I'm glad she recognises as the government has now brought forward in terms of leasehold houses. She also raises two very important points about reports, and I think it is important that we speak more about those, so particularly on the impact, so I'm keen to meet her to discuss those going forward. The Honourable Gentleman from East Ham, we are looking at the point about the building safety regulator, and I'm happy to talk to him separately when I meet with the Right Honourable Gentleman with regards to the barrier point. On asbestos, I have checked during the time that since he stood up. We do not believe that right is extinguished. But if we are not correct on that, I am keen to discuss it with him further to make sure that we understand exactly how that regime will work in practice and to try to assuage his concerns. My honourable friend from the City of London and Westminster, who made an extremely powerful case and exhorted us to move in this watershed moment. And I'm keen to talk with her further about the participation thresholds. I know, and she's made a powerful case both to me in this House today and more broadly about the importance of making sure that this is workable, particularly in the circumstances which are faced in the centre of London. The Honourable Lady from North Shropshire, whilst I do absolutely understand the point that she is making about some of the changes, I do worry about the clause which she has put forward. I would ask her not to push it to a vote. I think the concern I would have on that clause is, whilst the intentions are clearly noble, it does essentially get us into a place where assets are being expropriated for things that could be as insufficient as notice given on an AGM. So I would hope that she would reflect on that in the time that we have left, whilst understanding the intent behind it. My right honourable friend from Whittam makes a very strong point about making sure that we consider estate management. Further, we have given I've given that commitment from the dispatch box today to do so. And first point has been raised on a number of occasions, including by my right honourable friend from Whittam. It may interest the House to know that my honourable friend from Harborough has a Westminster Hall debate on these issues tomorrow. So same time, same place, same discussion, but an opportunity to discuss further those people and those organisations that are not doing the right thing within this area. And then finally, my honourable friend from North East Bedfordshire has been an absolutely doughty champion for progress on estate management. He is absolutely right to do so. His speech again demonstrates the strength of feeling on this. And as I've said at the dispatch box a moment ago, we are considering it further and recognise the importance of doing that. And then just finally turning to the honourable gentleman on the front bench of the opposition, he has brought forward a new clause with regards to forfeiture. I hope that the government has indicated very clearly about how we recognise the significant problems here and working through the detail. And whilst I do understand the point that the honourable gentleman is making both on Amendments 4 and Amendment 8, for the same reasons in committee, we think that it is proportionate to retain the current position that we have set out from this bench. Now, my honourable friends from Redditch and Harborough made a very clear case about the importance of these benches on this side leaning into reform. And in the time that I have left, knowing that other parties and other traditions represented in this House will make similar cases, this is a shared endeavour in this area, I just want to make the Conservative case again for leasehold reform. It is a Conservative government building upon its proud heritage of reform that is bringing forward the most transformative proposals for improving the lives of millions of leaseholders. It is a Conservative government that is building the case for change to deal with the iniquities present on new estates and is committed to setting ordinary families free from unnecessary burdens. It is a Conservative government that has brought forward one of the most comprehensive changes to property in a generation. And why have we come forward with these proposals? Precisely because it is a Conservative thing to do. We are cautious about interfering in the markets for fear of unintended consequences or the creation of barriers. We know that no government can ever fix every problem, but when we are convinced of reform, we will fight for it with every sinew. At the heart of being a Conservative is the desire to smash monopolies and the desire to remove bad practice. We will celebrate where things work well, but we will joyfully remove distortions which are exploited by chancers and rogues. And we will constrain rent seekers and middlemen who add little to the basic economic exchange of goods and services which are at the heart of our economy. Fundamentally, we are committed to making our markets more perfect and, as a consequence, setting people free to make their own choices, live their lives and build their own future. Leasehold has been exploited for far too long by those who have no interest in the good functioning of capitalism. The lack of transparency, the lack of clarity, the lack of redress in freehold estate charges causes frustration up and down the land, and it does nothing for the efficient functioning of markets. And that is why we are reforming When Adam Smith in 1776 talked of ground rents as monopolistic, when Hayek reminded us in 1944 of the importance of making competition work and not accepting institutions as they stand, and when, as my humble friend from Harborough indicates, Margaret Thatcher asserted in 1982, there is no prouder word in our history as Conservatives than freeholder. That is the centuries-long call as to why we have to make further improvements to our property system, and this bill today, in the true spirit of thousands of Conservative reforms that have made this country better, we are going to send a clear signal that change is coming, and change for the better, that will benefit millions of people for good for the long term. And that is only possible because of all of the hard work of all of the officials and all of the people in the Law Commission who have done so much work, and indeed my opposite number, who has been extremely constructive with regards to this. But I want to say a huge thank you to Professor Nick Hopkins, to Tom Nichols, to Chris Pullman at the Law Commission, to officials in the department led by Robin Froggatt-Smith, to the private office and Grace Dooley, to the valuable input of everybody across this House. And whilst I have just made the Conservative case for reform, we know that this is a shared endeavour amongst us all. It is why we have an unusual amount of unanimity in this place, and why it demonstrates the importance that we continue to make progress on this. And as this bill moves to the other place, I hope that those sat in the other place will take note of the consensus here about making progress. I hope they will take note about the keenness for us all to ensure that progress is made. I hope they will take note about the importance of making sure that this bill continues, and about the very many great reforms that are in this bill already, and demonstrating that together, as a broad group all across this House, we are committed to ensuring that leasehold reform happens. We are committed to ensuring that leaseholders get a better deal, and we are committed to ensuring that estate managers and estate management and freehold estates get clearer transparency, clearer information, and a clearer understanding of how they can live their lives and set themselves free in the future.
Order. Under the order of the House of 11th of December 2023, I must now put the questions necessary to bring proceedings on consideration to a conclusion. The question is that new clause 26 be read a second time. As many of that opinion say aye. Aye. Contrary, no. Ayes have it. The question is that new clause 26 be added to the bill. As many of that opinion say aye. Aye. The contrary, no. The ayes have it. Come to government, new clauses 27 to 35 and 42 to 66. Minister to move the new clauses formally.
Move formally.
Question is that new clauses 27 to 35 and 42 to 66 be added to the bill. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. New clause 1 has been selected for separate decision. Call Helen Morgan to move new clause 1 formally.
Formally.
The question is that new clause 1 be added to the bill. As many of that opinion say aye. Aye. Contrary, no. No. Division, clear the lobbies. Question is that new clause 1 be added to the bill. As many of that opinion say aye. Aye. Contrary, no. No. Tell us for the ayes, Alistair Carmichael and Jamie Stone. Tell us for the noes, Scott Mann and Mark Fletcher.
The ayes to the right, 14. The noes to the left, 304.
Losing here.
The ayes to the right were 14. The noes with the left were 304. So the noes have it. Unlock. New clause 5 has been selected for separate decision. I call Matthew Pennycook to move new clause 5 formally.
Move formally.
The question is that new clause 5 be added to the bill. As many of that opinion say aye.
Aye!
Contrary, no. No! Division, clear the lobbies. New clause 5 be added to the bill. As many of that opinion say aye. Aye. Contrary, no. No. The tellers for the ayes. Mary Glendon and Joel Jones. Tellers for the noes, Scott Mann and Mark Fletcher. Order.
The ayes to the right, 169. The noes to the left, 306.
Thank you. The ayes to the right were 169. The noes to the left, 306. So the noes have it. Unlock. New clause 39 has been selected for separate decision. Call Clive Betts to move new clause 39 formally. The question is that new clause 39 be added to the bill. As many of that opinion say aye.
Aye.
Contrary, no. No. Division. Clear the lobbies. Is that new clause 39 be added to the bill. As many of that opinion say aye.
Aye.
Contrary, no. No. Tell us for the ayes. Mary Glindon, Gerald Jones. Tell us for the noes, Scott Mann and Mark Fletcher. Order.
The ayes to the right, 179. The noes to the left, 294.
The ayes to the right were 179. The noes to the left were 294. So the noes have it. Unlock. We now come to Government Amendments 24 to 48, 85 and 49. Minister to move formally.
Formally.
The question is that Amendments 24 to 48, 85 and 49 be made. As many of that opinion say aye.
Aye.
Contrary, no. The ayes have it. Government new schedules 1, 2 and 3. Minister to move formally. The question is that new schedules 1, 2 and 3 be added to the bill. As many of that opinion say aye.
Aye.
Contrary, no. The ayes have it. Government Amendments 50 to 53. Minister to move formally.
Formally.
The question is that Government Amendments 50 to 53 be made. As many of that opinion say aye.
Aye.
Contrary, no. The ayes have it. Amendment number 4 has been selected for separate decision. Matthew Pennycook to move the amendment formally. The question is that Amendment 4 be made. As many of that opinion say aye.
Aye.
Contrary, no.
No.
Division. Clear the lobbies. The question is that Amendment 4 be made. As many of that opinion say aye.
Aye.
Contrary, no.
No.
Tellers for the ayes, Mary Glindon and Gerald Jones. Tellers for the noes, Scott Mann and Mark Fletcher. Order, order.
The ayes to the right, 171. The noes to the left, 300.
The ayes to the right were 171. The noes to the left were 300. So the noes have it. Unlock. Government Amendments 54 to 67. Minister to move formally.
Move formally.
The question is that Government Amendments 54 to 67 be made. As many of that opinion say aye.
Aye.
On the contrary, no. Ayes have it. Amendment 8 has been selected for separate decision. Matthew Pennycook to move the amendment formally.
Move formally.
The question is that Amendment 8 be made. As many of that opinion say aye.
Aye.
Contrary, no. No. Division. Clear the lobbies. Wait for it. What is this? It is that Amendment 8 be made. As many of that opinion say aye. Contrary, no. Tellers for the ayes, Mary Glindon and Gerald Jones. Tellers for the noes, Scott Mann and Mark Fletcher. Order. Order.
The ayes to the right, 170. The noes to the left, 299.
Thank you. The ayes to the right were 170. The noes to the left were 299. So the noes have it. Unlock. Government Amendments 68 to 82, 84 and 23. Minister to move formally.
Formally.
The question is that Government Amendments 68 to 82, 84 and 23 be made. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. Consideration completed. Third reading.
Now.
King's consent. Prince of Wales' consent. Under the programming order of the 11th of December 2023, I must now put the question necessary to bring the proceedings on the third reading to a conclusion. The question is that the bill be now read the third time. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. Order. Order.